May I request everybody to please take your assigned seats. The committee hearing of the Subcommittee on Correctional Reforms will now please come to order. May I request everybody to please stand as the Honorable Mercedes C. Cagas will deliver the opening prayer.
Holy presence of our Lord, in the name of the Father, and of the Son, and of the Holy Spirit. Heavenly Father, we come to you today asking for your guidance, wisdom, and support as we begin this meeting. Help us engage in meaningful discussions and guide our hearts and minds as we make decisions for the good of all those who have placed their trust and confidence in our leadership. Be with us in our deliberations and remind us of the value of fairness and guard us from blind self-interest. Remind us that all that we do here today is for the pursuit of truth, for the greater glory of you, and for the service of humanity. We ask these things in your holy name. Amen. In the name of the Father, and of the Son, and of the Holy Spirit. Amen.
The Honorable Salo is recognized for your motion.
Mr. Chair, I respectfully move that we dispense the calling the roll.
It has been moved and duly seconded that the calling of the roll shall be dispensed. Is there any objection? The chair hears none. The motion is approved. Where is the record open? Before we will proceed, the chair would like to recognize the presence of the following distinguished members of the House. We have here Deputy Speaker Castro, the Honorable Romeo M. Acop of the 2nd District of Antipolo City, who is the good chairman of the Committee on Public Order, the Honorable Ron P. Salo, who is the chairman of the Technical Working Group, the Honorable Jose Atinsa Jr., our very dynamic member of the House who represents the party list Buhay, the Honorable Deputy Speaker Gwendolyn Garcia of Cebu, the Honorable Mercedes C. Cagas of the Lone District of Davao del Sur, and the Honorable Franz Castro of the party list ACT Teacher. Distinguished colleagues, resource speakers, good morning and welcome to this hearing of the Subcommittee on Correctional Reforms. Today, the committee will hear and act on 3 major issues referred to us by the Mother Committee on Justice, bills and resolutions affecting the lives of our people, which should be acted with dispatch for the best interest of the nation. First, the committee will approve now the substitute bill regarding the lowering of the minimum age of criminal responsibility on House Bill numbers 2505, 935, 1609, 2009, and 3973, principally authored by no less than our House Speaker, the Honorable Pantaleon Alvarez, Deputy Speaker, Representative Castro, Congressman Vicente Yap, Tiangco, Cagas, Acop, and E. Swansing. These bills seek to reduce the minimum age of criminal responsibility from 15 years old, the other bills from 15 to 12, the others from 15 to 9. The subcommittee had already conducted a series of hearings on these bills and had invited almost 100 resource persons from different private entities, such as non-governmental organizations, and even a US-educated and trained expert on the evolution of human brain, cabinet secretaries who are members of the Juvenile Justice and Welfare Council, to enlighten the committee members and authors the wisdom and or the danger of lowering the minimum age of criminal responsibility from 15 to 12 or 9 years old, as the case may be. As an overview, the main objectives of the proponent of the bills are as follows: to prevent criminals from using children who are below the age of criminal responsibility in their nefarious acts, and to inculcate in the minds of the children that they are accountable and responsible of their actions. On the other hand, the primary objections of those who oppose is on the very idea of making children criminals, because the mere label of being criminals will condemn them for the rest of their lives. Once branded as criminals, it will almost be impossible to redeem themselves. Further, considering that in the scenarios contemplated by the proponents, children are primarily victims, then they should be assisted instead of being criminalized. I once heard from Secretary Briones of the DepEd saying that 9 years old are just grade 3 and 12 years old are just grade 6, and therefore they should need utmost guidance and protection from the state, consistent with the principle of parens patria. In order to expedite and to come up with the best action, the committee created a technical working group headed by the Honorable Salo of the Kabayan Party List, and ably supported and assisted by our former senator and now a hardworking congresswoman, the Honorable Pia Cayetano, whose advocacy on the welfare of children is beyond question, who will make and present today for our consideration and approval a substitute bill that will address the intention of the authors and consider the concerns of the oppositors. The second item on the agenda is the motu proprio investigation in aid of legislation on the alleged secret detention cell at the Manila Police District Station 1, Tondo, Manila, pursuant to the resolution of the Mother Committee on Justice in its last meeting. Under the House rules, the committee, upon the vote of 50% plus one of its members, shall conduct a motu proprio investigation on any matter brought before it. The last item of our agenda is the initial consideration of House Resolution number 314 and 874, principally authored by the Honorable Deputy Speaker Gwen Garcia of Cebu, calling for an investigation in aid of legislation on the proliferation of illegal drugs at the Cebu Provincial Detention and Rehabilitation Center, CPDRC, and the glaring gross mismanagement thereof. That is House Resolution number 314 and House Resolution 874, a resolution calling for an investigation in aid of legislation on the alleged cruel, inhuman, and degrading treatment of prisoners at the CPDRC during the raid conducted on February 8, 2017. As we all know, the Committee on Justice had just successfully conducted an investigation in aid of legislation on the proliferation of illegal drugs at the National Bilibid Prison. All in the items of our agenda are very contentious issues. And with that, we have invited different resource speakers today to shed light to the committee on the facts and circumstances surrounding the occurrence of the events with the end view of coming up the necessary legislation that will improve the country's correctional facilities and jail management. Before we will proceed, may I call the committee secretary to acknowledge the resource persons present and thereafter administer their oath accordingly.
Mr. Chair, may I take your name?
Thank you, Your Honor. Good morning. The committee acknowledges the presence of the following guests and resource persons: the Honorable Governor Hilario David III, Governor of Cebu; Commissioner Karen Gomez Dumpit from the Commission on Human Rights; Police Director Oscar Albayalde from the PNP. Also from the PNP, we have Police Chief Superintendent Fausto Manzanilla Jr., Police Chief Superintendent Joel Napoleon Coronel, Police Superintendent Robert Domingo, Police Senior Inspector Edwin Fugan, Police Senior Superintendent Francisco Gabriel Jr. From the DILG, we have Regional Director Rene Bordeos. From PDEA, we have spokesperson Mr. Derek Carrion. From the DOJ, we have Attorney Genesis Gatdula. Also from the CHR, we have Attorney Diana De Leon, Attorney Brenda Canapi. And we also have from Cebu, board member Sun Chimura. For the resource persons, please rise.
All resource persons.
All resource persons and witnesses and guests, please. Please raise your right hands. Do you swear to tell the truth, the whole truth, and nothing but the truth before these proceedings? You may take your seats.
Thank you, Committee Secretary.
Mr. Chair.
Yeah, the Honorable Deputy Speaker, Gwen Garcia.
Thank you, Mr. Chair. Inasmuch as my resolutions, Resolution 314 and Resolution 874 are scheduled as the third item in the agenda, and because I am needed right now in the Committee on Good Government, may I take leave, Mr. Chair, with the assurance and promise that and commitment that I shall be back once the House, the both resolutions shall be taken up by this subcommittee.
Okay, the Honorable Deputy Speaker is excused.
Thank you.
Now, the Chair would now like to recognize the Honorable Ron P. Salo for the presentation of the substitute bill and for any action in relation to its approval after your presentation. You have now the floor.
Thank you very much, Mr. Chair. Mr. Chair, honorable members of this committee, resource persons, and guests. It is my pleasure and privilege to report to you the technical working group output that was a product of several meetings and discussions on the proposed legislative measures concerning the proposed minimum age of criminal responsibility. Mr. Chair, in order to come up with a more acceptable version, the technical working group members first identified the main objectives of the proponents of the bill, as well as the main concerns raised by stakeholders and those opposed to the measure. As was mentioned a while ago by the Honorable Chair, there are two main objectives of the proponents of the measure. First is to prevent criminals from using children who are below the age of criminal responsibility in their nefarious activities. And second, to inculcate in the minds of these children that they are accountable and responsible and ultimately may be held liable for their actions. On the other hand, the primary objection of those opposed to the bill, as was mentioned by the Honorable Chair, is the very fact that the mere label of being criminals will condemn these children and put a stigma on them for the rest of their lives. Once branded as criminals, it will almost be impossible for these children in conflict with the law to redeem themselves and become productive citizens of the country. Considering that children do not have yet the full capacity to understand the extent and consequences of their actions, it seems harsh and unjust to judge them by the same standards society uses in judging the actions of adults. Furthermore, as was also mentioned by the Honorable Chair, considering that in the scenarios contemplated by the proponents of the bill, children are primarily victims. As such, they need to be assisted and guided instead of being criminalized. Finally, consistent with the principle of parents patrae, the state needs to provide children that most protection they need. After thorough discussions, the technical working group agreed that children should be made accountable and liable for their actions, but without the corresponding label as criminals. As such, the technical working group agreed that the minimum age of criminal responsibility will not be lowered to the current 15 years. However, CICL aged below 15 years should not be immediately released, as currently allowed under the law. Instead, they should be immediately subjected to intervention programs of the government in order to begin their rehabilitation and reintegration to society. These proposed amendments are contained in Section 2 of the proposed substitute bill. I understand, Mr. Chair, that the proposed substitute bill has been distributed to the honorable members as well as to our guests. Also, as discussed and agreed upon by the TWG members, the establishment and operation of Bahay Pag-asa shall now be under the DSWD, as opposed to the present setup where the responsibility for its establishment and operation is lodged with the local government units. The technical working group learned that despite the mandate given to the LGUs under the law, very few LGUs have established their respective Bahay Pag-asa for various reasons. The technical working group therefore is convinced that it's more appropriate for the DSWD to be primarily responsible for the establishment and operation of Bahay Pag-asa. This matter is incorporated in Section 1 and Section 9 of the proposed substitute bill. In order to further discourage, if not totally eliminate, the use of children by adults in their commission of crimes, Section 3 increases the penalty of exploitation of children for the commission of crimes. It incorporates a proposal agreed upon by the technical working group to impose a tiered penalty based on the crime which the child is induced or coerced to commit. This is, as I mentioned, contained in Section 3. Further, in order to remind parents of their primary obligation of rearing responsible children, Section 4 mandates the parents of CICL to undergo mandatory counseling and intervention and penalizes parents of CICL who fail to undergo the same. It also carries the liability of parents for damages, which shall be primary for civil damages arising out of the actions of the CICL. Further, in order to underscore the reduced capacity of children in decision-making, Section 5 of the proposed substitute bill adds a new section for the reduced sentence of CICL convicted by the courts. For crimes punishable by the revised penal code, the penalty shall be 2 degrees lower, while for special laws with fixed period of imprisonment, the period shall be halved. Life imprisonment shall be lowered to imprisonment of up to 12 years. In order to maximize the rehabilitative and integrative programs of the government to ensure that the CICL become productive citizens, Section 6 increases the maximum age for the extension of the suspended sentence from 21 to 25 years. in order to reward CICL for good behavior. Section 7 deducts the time served by the CICL under diversion, intervention, rehabilitation, or detention from the period of sentence in accordance with Article 97 of the Revised Penal Code. On the other hand, Section 8 underscores the penalty for the violation of the confidentiality of records of the CICL. Section 10, on the other hand, mandates the confinement of CICL convicted by the court to agricultural camps or training camps established also by the DSWD in coordination with relevant agencies of the government. The DSWD is mandated to establish at least 2 agricultural camps and training facilities, each in Luzon, Visayas, and Mindanao, which shall have separate facilities for male and female children. May I just inform or point out, however, that the proposed substitute bill that was distributed to the honorable members did not yet contain this proposed transfer of responsibility from Bucor and TESDA with the DSWD. As proposed and was discussed last night, it will now be sole responsibility of DSWD in coordination with Bucor and the TESDA. Section 11, on the other hand, Mr. Chair, adds accredited foster parents to the list of persons to whom a CICL may be released after availing of community-based rehabilitation. And finally, consistent with what has been contained in the proposed substitute bill, the title of the bill will reflect now the changes and proposals as approved by the technical working group. And it shall now read, an act expanding the scope of the juvenile justice and welfare system and strengthening the social and reintegration programs for children in conflict with the law, amending for the purpose Republic Act 9344 as amended, otherwise known as the Juvenile Justice and Welfare Act of 2006. That's all, Mr. Chair, and good morning.
Okay, thank you very much, the Honorable Salo.
Mr. Chairman.
Before we will proceed, and before I will recognize the Honorable Atienza, the Chair would like to acknowledge the presence of Deputy Speaker Pia Cayetano, Deputy Minority Leader Alfredo Garbin Jr., and Representative Carlos Isagani Sarate. And we have also the Honorable Ruel Gonzaga, who has just arrived. The Honorable Atienza is recognized.
Thank you, Mr. Chairman. For purposes of clarity and appreciation, as we congratulate the TWG on their work, of obviously listening to the clamor of the greater majority of those who spoke earlier in this committee in its hearings, to readjust the good intentions of the proposed law lowering the age of criminal liability. But may we get a direct answer from the chairman of the TWG as to how he would now define this? Are we now lowering the age from 15 to 12, 9, or are we totally pegging the age of criminal liability to 15, meanwhile just strengthening the good effects of other provisions affecting those below 15?
Before the Honorable Salo will respond to the question, the Chair would like to acknowledge the presence of the Honorable Remisias Agabas, the good chairman of the Revision on Laws Committee. Yes, the Honorable Salo, you have the floor.
Thank you very much, Mr. Chair. The age of criminal responsibility is provided for under Section 20 of the current law, and also contained under Section 2 of the proposed substitute bill. In this particular provision, the age of criminal responsibility pegged at 15 wasn't changed, except that, of course, as was mentioned a while ago, the age of 9 to below 15 is what we call the age of social responsibility. For these children who are in conflict with the law, they are called children in conflict with the law, CICL, will be subjected to mandatory intervention by the government in order to ensure that they are rehabilitated and reintegrated to society.
That's clear, Mr. Chairman. Therefore, we would like to ask how and why and what further punishment do we met out those who are guilty and exploiting the children in criminal activities like parents, syndicates, crime syndicates, police enforcers who are also utilizing children in their criminal activities. So all of these elements should be given heavier penalty. And if so, what kind of heavier penalty does the substitute bill envision?
The Honorable
Mr. Chair, with respect to the penalties to be imposed on adults who are exploiting children, this in particular matter is provided for under Section 3, and they will be penalized heavily. Under Section 3 of the proposed substitute bill, which amends Section 20C, it states, Section 20C, exploitation of children for commission of crimes. Any person who in the commission of a crime makes use, take advantage of, or profits from the use of children or a child, including any person who abuses his or her authority over a child, or who otherwise induces or coerces a child to commit a crime, shall be punished by reclusion temporal if the crime committed is punishable by imprisonment of 6 years or less, and by reclusion perpetua if the crime committed is punishable by imprisonment of more than 6 years. So there are just two punishments that may be meted out on those who exploit children. First, if it is the punishment, if the crime committed by the child is below 6 years, punishable by below 6 years, then the punishment is ×2 to the person who induced him or who used him. That will be reclusion temporal. But beyond 6 years offense committed by the child, then it's reclusion temporal for those who use him.
Basically,
Perpetua. Sorry.
Basically, Mr. Chairman, what the working group chairman is saying is that the substitute bill now contains double penalty for those who exploit children in their criminal activities. Am I correct in assuming that?
Precisely, Your Honor.
Thank you. Now, as to the responsibility of parents and the community where the children are exploited, how does the technical working group answer the basic question of family responsibilities to bring up their children too properly so that they cannot be exploited? They will not be exploited by criminal activities or criminal syndicates.
Yes, the Honorable Salo, you may respond.
May I respectfully reiterate what I mentioned a while ago, that in order to remind parents of their primary obligation of rearing responsible children, Section 4 of the proposed substitute bill mandates the parents of CICL to undergo mandatory counseling and intervention, and penalizes parents of CICL who fail to undergo the same. Further, it also clarifies that their liability is primary for damages, for civil damages arising out of the actions of the CICL. So there are two. First is the civil liability of the parents. Then second, they are quote-unquote socially responsible in the sense that they have to undergo mandatory counseling and intervention programs by the government. Their failure to attend these mandatory intervention programs by the government will subject them to criminal liability.
Again, we appreciate the change that has been put into the substitute bill. But at the proper time, we would introduce an amendment to that to make sure that the parents gets the most penalty out of all of these problems of society. Wala na pong mas mahigit pang merong kakayahan na mag-control ng mga bata, as we consider them children, except the parents. So they should also be made the most liable and the most penalty, and not just counseling. They should be penalized so that they will remember not to allow the children to go the wrong way. It's the home, it's the parents, and the family which can be of big help in this problem where society obviously is failing. Enforcement, community, government, society, we are the ones failing here. And in that particular appreciation, it is the family and the parents who should be made most responsible. So we reserve the right to propose amendments at the proper time.
Thank you very much, the
Mr.
Honorable
Chairman.
Atienza, for your brilliant interpellation to the chairman of the technical working group. Now, before the chair will recognize my idol, Deputy Speaker Fred Castro, I would first acknowledge the presence of Representative Amy De Jesus. Deputy Speaker, you are now recognized.
Mr. Chairman, by way of comment, I would like to remind the good gentleman from Manila and party list, Buhay, and all those who have similar concern, that we should not, in this amendatory bill, we should not pinpoint sole responsibility on parents. Responsibility here is contributory. Contributory among all stakeholders. And who are these stakeholders? We have the parents, we have the government. And insofar as the government is concerned, we have the different departments of the government considered a stakeholder, like, for example, the Department of Education, the Department of Social Welfare, the Department of Health, and even the church is considered stakeholders here. And therefore, we should not attribute in this bill sole responsibility on the part of the parents. All stakeholders shall be considered. That is all, Mr. Chairman.
Mr. Chairman, just to put the records clear,
Yes,
that's exactly what I said. Immediately reiterated what I said. It's society, government, enforcement, even communities, and families. So before the good gentleman gets excited with his dissertation on responsibilities, I agree with him.
Okay. The chair,
Mr. Chairman,
yes,
short
the Honorable
reply.
Castro.
I am not excited. I am interested to hear always Congressman Atienza.
Well, I agree with you. That's the problem.
So, the chair take notes that while we are discussing here children in conflict with the laws, there is no conflict with the manifestation of the Honorable Atienza with that of the Honorable Deputy Speaker. Yes, if there are any other remarks or comments before I will allow the chairman of the TWG for a reply and for appropriate motion. The Honorable Alfredo Garbin Jr., Deputy Minority Leader, is recognized.
Thank you, Mr. Chair. I congratulate the chair of the TWG for that report. I agree that children are mere victims because of their circumstance whenever they are used by adults, especially adult syndicates. Most of the children are being used by criminal syndicates. If you look at their circumstance, they are neglected, abandoned, uneducated, and because of this circumstance, they are being made victims of these adult syndicates. And it's just right that the focus should be on these adult syndicates, providing more steep penalties in order to penalize those who are using minors or those who are using children. And we have also international agreements that we must respect, especially the conventions on the right of the child. And I congratulate again for respecting all those international agreements. That when this TWG report was crafted, it was made into consideration. Now, my concern, Mr. Chair, is on the institution establishment of Tibahay Pag-asa, because that's where the problem lies when it comes to LGUs who doesn't have the capacity to establish Bahay Pag-asa. I understand that in the said mandatory provisions of the bill, it was provided that those LGUs who doesn't have the capacity to establish Bahay Pag-asa, they can write or give that responsibility to DSW. Could you please further clarify on that, Mr.
Well,
Chair?
the Chair would like to clarify the Honorable Garbian that under our existing law, which is the Republic Act 9344, known as the Pangilinan Law, the Bahay ng Pag-asa or the Bahay Pangarap is under the jurisdiction of the local government. The local government, the provincial government, is mandated to establish a Bahay ng Pag-asa, Bahay Pangarap. Under Section 1 and Section 9 of the substitute bill as presented by the Honorable Salo, that this Bahay Pag-asa will now be transferred fully to the DSWD. No longer with the local government, because of the factual information that since the approval of the law, RA 9344, there has been only 50% of the local governments have established the Bahay Pag-asa. So that when this will be transferred now by the DSWD, once we approve this bill into law, then there will be the corresponding appropriations so that it will be complied accordingly in order to comply the mandate of this law. So the Chair would like to recognize the Honorable Pia Cayetano, who is one of the brainchild in this substitute bill. The Honorable Deputy Speaker is recognized.
Thank you very much, Mr. Chair. I would just like to put on record a few things. First of all, the bill we have today is a collaborative work between the members of Congress, and I'm really honored to be a part of this. We really work together to reconcile the various concerns and, to a large extent, conflicting views of different parties. But we feel strongly that this is a measure that addresses all the concerns. Now, there's no perfect bill, but we do believe it addresses the major concerns. Number one is the reality, and I don't think anyone in the hearing, regardless of the position they take on lowering the age of criminal responsibility, can deny that we have thousands of children being taken advantage of and introduced into a life of criminality at a very young age. And if you ask the people on the ground, the barangay captains, those of our colleagues who are very involved in their communities, they all know that the law as it stands for the last few years has not been able to address this concern. These children are, on the one extreme, blatantly waive their birth certificate at law enforcers to show that they cannot be apprehended because they are less than 15. And on the other extreme, barangay captains or law enforcers who are also very hands-on would do their best within the confines of the law to either keep this child with them for the day, make sermon, lecture, but at the end of the day, they have to release these children. So bearing these things into account and knowing that we are not doing our children justice by allowing this situation to continue, what we decided to put together was a bill that will now recognize that these children must take responsibility for their actions. So as young as 9 years old, 10 years old, the bill, the intention of the bill is to tell the parents, to tell the children, to tell the entire community that no, you must be responsible for it, because for some reason, the law in a way has been taken advantage of and has been given the impression that it's okay for these children to commit these petty crimes. It's acceptable because they are young, they don't know what they're doing. But that is not the intention, but that is how our current situation is. So this bill emphasizes that no, you are responsible and there are consequences for your action, even if you are 9 years old or 10 years old. The state will take responsibility and discipline you if your parents cannot do that. And that is why, as outlined by the chair of our technical working group, there are now details within this bill that will allow the state to take over parental responsibility in that sense by putting them in the corresponding intervention programs that would work for each child. So again, we recognize parental responsibility because the law here first makes a determination if the parent is not capable of taking care of this child. So hindi yan agad-agad tinatanggal sa parents. But if it is clear, and again, for those of us whose job requires that we know what's going on in our barangays, a lot of barangay captains, a lot of law enforcers will tell us that there are parents na pabayang-pabaya talaga sa mga anak nila. There are parents who will actually tell the barangay captains and the police, please kunin nyo na yung anak ko na yan. Meron ho talagang ganon. For those of the advocates here who have put on record that the child should always be with the parents, unfortunately po, meron din, sadly. May parents who either cannot take on the responsibility or have chosen not to be responsible parents. So basically, that's what this is. If the parents cannot do their job, then the state comes in and takes over that job. But what we have tried to do is to remove that stigma of being a criminal. But all the intervention programs are there and even strengthened further. So I do believe that we were able to find a balance here. And if there are any areas that we have not addressed, no, I know that the committee is very welcome to look into that. Just to quickly respond to the Honorable Atienza's concern, what we initially thought of doing here was to give the parent the chance also to be reformed by attending the seminars also, no? Because I think many of us would also know of very good parents who, no matter, despite their good intentions, may have a child that was lured into a world of drugs or whatever. So the first intention also is to give the parent that opportunity to attend these seminars and to also undergo the training programs. And refusal to do so would be subjecting them to the criminal sanctions also. So that's all for now,
Mr.
Chair.
Chairman.
Thank you.
Yes.
I just would like to clarify, because there seems to be a misinterpretation of our position. We agree that there are parents who should be prosecuted. And I hope the good Congresswoman, Deputy Speaker, agrees with that, with the statement that there are parents who are really guilty of negligence or probably even criminal liability. So there is nothing wrong with making sure that these parents are also punished accordingly, so that the age of counseling and sermonizing in the barangay level is already past. Ako po yung nag-chairman ng 10 taon, alam ko po itong isyong ito. Kapag ka ang isang tao ay hindi na makukuha sa ganung klaseng paraan, sermon, counseling, seminarizing, dapat ikulong na yung parents dahil they are equally criminally liable for the actuations of the children. Yun po ang point namin.
Okay. Before I'll recognize the chairman of the TWG for his response, the chair would like to recognize the vice chair of the Committee on Justice, the Honorable Ching Biloso. Honorable Salo, before I'll give you the floor, can I first recognize the Honorable Sarati for his interjection? Okay, the Honorable Sarati is recognized.
Maraming salamat, Mr. Chair. Una sa lahat, Mr. Chair, pinasasalamatan natin yung technical working group, no, for trying to harmonize the concerns of all stakeholders, no, especially yung mga advocates, ng child rights advocates. At nakita nga natin, Mr. Chair, no, na tama na hindi itratuhing kriminal ang mga bata, bagkus dapat silang tingnan na biktima. At mas malaki ang kasalanan ng isang lipunan na nagluwal ng mga ganitong batang in conflict with the law. No? Ang tanong ko lang dito, at para masagot na rin mamaya ng head ng technical working group, yung sinasabi nating pangililan law, ang isang kahinaan talaga doon ay una, yung pagpupondo doon sa mga struktura na dapat ay meron ngang intervention, no? Para ang ating mga kabataan na in conflict with the law ay there's a rehabilitation na mangyayari. And I observe, Mr. Chair, dito sa ating substitute bill, ang dami nating pinanukala dito, no? Ibalik na sa nasyonal yung lahat na bahay pag-asa, although in passing nadaanan yan kanina, no? Pero if it will again depend on the annual debate on how much appropriation will be given to this bahay pag-asa at hindi nakalagay dito na merong talagang pondong sigurado, wala rin hong mangyayari dyan. Pangalawa, may mandato rito na gumawa tayo ng mga agricultural camps, 2 sa bawat isla. Saan ho kukunin ang pondo nito? Baka ho muli ay magiging isang empty na batas na naman ito na taon-taon ay naglalabi ang ating mga ahensya na punduhan nyo na ho ito dahil marami nang dapat na ilagay sa agricultural camps at wala namang pondo. No? So sa tingin ko, Mr. Chair, ay dapat ma-address na ito ngayon ng substitute bill kung gusto nating ma-plug yung mga leakages, no, or mga kahinaan ng mga ng kasalukuyang batas. Thank you, Mr. Chair.
Yes, in connection to the proposed appropriations as insinuated by the Honorable Sarate, we are still making contact with the DSWD, and probably once we will treat this matter in the Mother Committee before it will be forwarded to the plenary, this has to pass through with the Committee on Appropriations, and rest assured that that concern will be taken care of. So, may I now recognize the Honorable Salo for an appropriate motion in relation to this?
Perhaps before, Mr. Chair,
You can
before
make any reply if you wish to make
I
some
wish
reply.
to clarify first the concern raised by the Honorable Atienza a while ago. Mr. Chair and the honorable members, may I respectfully inform you that parents themselves or guardians who are actively involved or uses or induces their children or coerces their child to commit a crime are equally liable. As mentioned under Section 20C, it mentions here any person, regardless whether they are the parents or the guardians. So the penalty that will be imposed on them will be twice higher than the crime that was committed by the child. But of course, with respect to the failure of the parents to guide properly their children, there has been so much debate within the technical working group whether that would amount to criminal negligence. And of course, there were concerns on the constitutionality of making parents criminal because the concept of criminal is something that is personal to the person who commits it, unless it amounts to criminal negligence. But in this particular case, Mr. Chair, may I respectfully inform you that there was no consensus among the members on what would be the threshold to define that criminal negligence. In this regard, as I pointed it out, Section 20C provides that if they commit the crime, then they are equally liable twice the penalty. But if it does not amount to a criminal act, then they will be subjected to counseling and intervention. But their failure to undergo that mandatory counseling intervention will be criminalized by the state. Thank you very much, Mr. Chair.
Mr. Chair, we reserve our right to bring the matter to the plenary when this bill reaches the floor, because we would insist that there is such a thing as criminal negligence.
Yes. Mr. Chair, we will certainly appreciate proposals in order to further enhance the provisions of the bill, as well as the other members who wishes to further enhance the portions on appropriations, and as much as we understand that that particular concern has cropped up for so many times in all the meetings, and we will certainly be happy to include those perfecting amendments.
Okay, thank you very much, Honorable Chair of the TWG. Before the Chair will recognize the Honorable Gonzaga, the Chair would like to acknowledge the presence of our very active Senior Deputy Majority Leader, the Honorable Rimpi Bundok, sir. And the Honorable Joseph Stephen Paduano. Okay, the Honorable Gonzaga is recognized.
Thank you, Mr. Chair. Good morning. This is with regard to Section 20-D. It says here, joint parental responsibility. The court may require the parents of a child in conflict with the law to undergo counseling or any other intervention. So if there is this child in conflict with the law, the parent of that child will be required by the court to undergo counseling. And if the parent will not obey the order of the court, paragraph 2 of Section 20D will apply. It says here, unless prevented by a lawful cause, shall be a ground for imprisonment for at least 30 days, but not more than 6 months. But in our present jurisprudence and existing law, if a person will not obey a lawful order of the court, that would be a contemptuous act. In this case, it is no longer a contempt, but it is a criminal act. So what would be now the distinction if a person, like for example, a person will not obey the lawful order of the court, like for example, subpoena duces tecum, he will be subjected to a contempt. Now, what would be the difference between the act of that person and the act of this parent? In this case, a mere failure of the parent to obey a lawful order of the court, that would be subject to a 30-day imprisonment up to 6 months. Instead, this should be a contemptuous act. So I would just like to clarify this, because a mere failure, a mere definition of the jurisprudence and lawful existing laws says that that act should be a mere contempt. So that would be my first concern, Mr. Chair. Second,
Okay, you finish first your all concerns or all your queries.
yes, thank you, Mr. Chair. Second, this Section 20-C. It says there are 2 penalties here. If the crime committed by a child is less than 6 years below, that would be subject to an imprisonment of reclusion perpetua temporal. And if the crime is more than 6 years, that would be reclusion perpetua, and that would be subject to the parents, to the one who induces the child to commit a crime. Now, I will give you a scenario. For example, we have a child. I am the one who induced the child to sell an illegal drug. If that child will sell an illegal drug, that would be, my offense would be reclusion perpetua, of course, because that would be 6 years and above. In the event the death penalty will pass before the Senate, because we have already passed that bill. In the event that bill will pass in the Senate, therefore the penalty would be death penalty. Now, in the event there will be a passage of death penalty, is it not the Section 20C will be in conflict with that law? My raising a point would be hypothetical at this point. But, like for example, there is a child and I was the one who induces the child selling a drug, illegal drug. I am a principal. Therefore, my penalty should be death. Is it not we are reducing the penalty under this bill? Instead of giving me death, you are giving me reclusion perpetua. Thank you, Mr. Chair.
Okay, thank you very much, Honorable Gonzaga, for your sharp legal observation. and considering that you are raising an issue which is justiciable issue, I will give you the person coming from the judiciary, who is our very energetic Vice Chair of the Committee on Justice, the former retired Justice of the Court of Appeals, and now our distinguished colleague, the Honorable Ching Biloso, to respond to your legal query. Honorable Biloso, you have the chair.
I will complicate the problem some more. If you examine the revised penal code, crime basically is defined in Article 3. It is distinguished this way, Dolo, meaning a crime committed with criminal intent, meaning that the criminal has that discernment, versus culpa, which is a crime committed by negligence. An example of that is Article 365 of the revised penal code. If, for example, a 16-year-old, or a 19-year-old person runs over a child, he did not have the criminal intent to run over the child. He did not have the criminal intent to kill the child. But he is liable because of the reckless imprudence he committed, which resulted, for example, in the death of the child. Now, I will go flashback. In my time, and this is 7 decades ago, when I was a child, I did not have a problem with my being 9 years old or over. Now we have increased, the law increased the age of criminal liability to 15. There is an attempt to reduce that to 9. That's a problem that will have to be definitely tackled at the plenary. I am going straight to the criminal negligence. What is the difference between a child criminally liable now under this law who commits reckless imprudence versus an 18-year-old child? Because I still treat an 18-year-old boy or girl as a child, at least by my standard in my family. Bata pa rin yan eh. Iba talaga yung may sufficient discernment ka na. To me, a crime that constitutes criminal negligence is well defined in the revised penal code. No ifs, no buts. Criminal negligence is criminal negligence. There is a corresponding penalty. A crime that is committed with deliberate intent, classified as dolo, under Article 3 of the revised penal code, is another matter. This is something that we in Congress should really study further. Thank you, Mr. Chair.
Okay. Before I'll recognize the chairman of the TWG for the appropriate motion, the Honorable Mercedes Cagas, who is one of the authors, is recognized.
Thank you, Mr. Chairman. May I ask, I would like to make a manifestation, Mr. Chairman.
Go ahead.
As one of the authors of this bill, may I just highlight some points before the subcommittee decides on the fate of this bill. 1, I stand for my bill in proposing that children offenders as young as 9 years old must be subjected in government intervention. 2nd, I share the opinion of my colleague who is also a proponent of the bill, Honorable Fred Castro, when he said, and I quote, that focus of the bill is not on the imprisonment, but rather on rehabilitation, intervention, and diversion in accordance with RA 9344. Third, I abide by the belief of the President that the enactment of this measure will prevent cold-blooded syndicates for using youth offenders to carry out their criminal operations. Mr. Chair, children as young as 9 years old engage in criminal acts because they are being exploited by parents, relatives, and even powerful people. And sometimes parents are also exploiting their own children into and engaged into a prostitution. It's not only criminal, but also engaged in prostitution. Lastly, Mr. Chair, I would like to put an emphasis on the role of LGO in the full realization of this bill. For several meetings we conducted on this bill, we have heard staunch opposition from NGOs and even from concerned agencies in the government sector. They say that the lowering of minimum age of criminal responsibility is wrong, with reference always to the issue of discernment. Inaccurate data on actual CICL is the countryside was presented by stakeholders contradicting the bill. Now, why is it inaccurate? It is because the same stakeholders admitted that one of the major issues with the previous bill is in the inefficiency of the LGU, citing that there have been undocumented reports of the juvenile violations under RA 9344 since its enactment because the LGUs failed to coordinate with the local councils for the protection of children. The success of this bill, or any legislation for that matter, depends greatly on how the frontliners in the implementation and enforcement respond to their duties. Mr. Chair, it is imperative that the legislative mandate translate into resources and administrative procedures to implement the law. If not, justice will remain elusive. Hence, let us not make the same mistakes. Instead, let us extract a lesson or two from the past. Let us work all together to instill the essence of responsibility in the minds of the youth and to ensure that they will get the protection and intervention that is right for them, not just for their good, but for the welfare of the whole country. I am calling on all the duty bearers, especially the local government units, the PNP, the barangay officials, to carry out the provisions of this bill if approved with respect, diligence, and courage. Thank you, Mr. Chair.
Thank you very much, Honorable Cagas, for your manifestation. The Chair would recognize one more manifestations before the TWG Chairman would file the appropriate motion in relation to the subject matter so that we can proceed to the next item of the agenda. The Honorable Franz Castro is recognized.
Salamat, Mr. Chair. Ako po ay magpapahayag ng aking manifestasyon kaugnay nitong proposal na ito dahil bilang nasabi ko na po bilang guro at ina ay parang hindi ko talaga makonsensya na ibaba yung criminal responsibility or liability na isang bata mula sa 15 hanggang 9 o pababa ng 9. Marami na nagsabi na ang mga batang ito ay na-influence or napabayaan ng kanyang mga magulang o impluwensya ng mga sindikato o hindi gaanong na-guide. Sinasabi din dito sa bill na ito yung mga intervention na gagawin. Pero pag tinignan po natin sa kabuuan ng ating lipunan, sinasabi nga natin sa eskwelahan, the community will educate a child. So buong komunidad po ang nagtutulong-tulong para mapabuti ang buhay ng ating mga children. Kaya po recognize po ng committee na ito, recognize po ng mga author na karamihan po ng mga nabibiktima ng ganitong criminal acts ay yung mga batang alam naman natin ay mula dun sa mga mahihirap na mga pamilya na vulnerable. Bakit ba yung mga mahihirap? May mga bata na wala sa school. Bakit ba ang mga mahihirap na mga bata ay nagugutom? So ito po ay responsibilidad ng adult. Kaya ito pong representasyon na ito ay kailanman hindi mas makonsensya na maibaba talaga ang criminal responsibility. Sa ganito pong kalagayan ng ating lipunan ay dapat na mangalaga dito sa ating mga children po na na-involve sa kriminalidad. Salamat po.
Okay, thank you very much, the Honorable Castro. One of the distinguished authors, the Honorable Romeo Acop, is recognized for his pleasure or whatever manifestation before the TWG chairman will file the appropriate motion.
Thank you, Mr. Chair. Magandang umaga po sa atin lahat. I'm one of the authors of the bill who would like to lower the age of criminal responsibility from 15 to 12. However, I would agree to the fact that the TWG chairman made some revisions and so far as the other bills are concerned together with mine, and I do not have a strong disagreement with what the TWG has come out with. However, I would just like to point out one observation, Mr. Chair. If we look at it, there's a law, the current law, and we have seen its implementation for so many years. Now, we're looking at a substitute bill that will also have the same problem, Mr. Chair. Nung una, yung implementation ng problema eh. The capacity of the local government units to implement their part of what is provided for by the law. Ngayon, titingnan naman natin, binigay natin sa DSWD yung karamihan ng responsibilidad. But nowhere in the law or in the substitute bill would we find a strengthening of the DSWD, which would bear the burden or the brunt of the implementation of this substitute bill if ever it becomes a law. So yun po ang magiging problema. Basically, yung current law, yun na ang problema. Ngayon, marami tayong binigay na tasks and responsibilities sa isang ahensya, pero this representation has not seen any provision in the substitute bill that would strengthen or capacitate the DSWD, Mr. Chair. So yun lang po ang concern ng author na ito. Thank you.
Thank you very much, the Honorable Acop. The Chair take notes of your manifestation, and the committee will still have to meet, the mother committee, to approve our recommendation, and that manifestation shall be properly considered. The Honorable Salo, you have.
Thank you very much, Mr. Chair. Before I respectfully go to the awaited motion, perhaps we're just discussing here that we can consider providing an oversight provision where Congress and other departments will be a member of that particular oversight committee to ensure the proper and effective and efficient implementation of this bill. With having said that, Mr. Chair, and having heard all the comments of our resource persons, as well particularly the authors of the bill, on how to improve or enhance the provisions of this bill, I respectfully move, Mr. Chair, for the approval of the substitute bill of the submitted by the technical working group. So moved.
It has been moved by the Honorable Salo, duly seconded by the Honorable Acop, that the substitute bill as presented shall be duly approved by this committee. Are there any further remarks?
Mr. Chair,
Comments?
just for the record, may I just
Yes.
register that the fact that I will have to abstain still on the approval of the bill, subject to the concerns raised earlier by the different members of the committee. And so at this point, I will have to abstain from voting on the approval or non-approval of the bill.
Okay. Any objection? The chair hears none. The motion is approved. Thank you very much, the Honorable Salo, the Honorable Cayetano, and the members of the Technical Working Group for the efforts exerted. Now, let us proceed to item number 2 of our agenda, which is the motu proprio inquiry in aid of legislation on the alleged secret detention cell at the Manila Police District Station 1, Tondo, Manila. For this item in the agenda, the chair would like to recognize the Regional Director of the Philippine National Police, NCR, National Capital Region, Police Director, Deputy Director General Abayaldi, to brief this committee on the facts and circumstances that happened, considering that the Manila Police District is under your direct supervision as Director of the NCRPO.
Thank you, Your Honor. With the permission of the Honorable Chairman, sir, may I ask the District Director, Police Chief Superintendent Joel Coronel to provide the briefing. He is more aware on the situation since he's the direct commander of the Manila Police District, sir. Yes, sir.
Okay. As manifested by General Abayaldi, the Police Senior Superintendent Joel Coronel is recognized.
Good morning, Your Honors. Good morning to everyone. I am Police Chief Superintendent Joel Napoleon Coronel, the District Director of the Manila Police District. As directed by the Chair, allow me to give a summary on highlights of the incidents relating to the inspection conducted by the Commission on Human Rights last April 27, 2017. As reported in various news and media outlets, an inspection and visit was conducted by the CHR at the Tondo Rahabago Police Station 1, located in Tondo, Manila, led by Attorney Gilbert Boiser of the CHR NCR, wherein allegedly there were 12 detainees found in a secret lockup cell inside the police station. And as a result of this, the PNP, with express orders from our regional director, has directed an investigation on the matter. And for this reason, the station commander at the time, Superintendent Roberto Domingo, has been relieved from his position, along with 14 other personnel who are all members of the Station District Enforcement Unit or Anti-Illegal Drugs Unit. And immediately after the visit, the 12 detainees who were found being held in the lockup cell were ordered transfer to the Manila Police District Headquarters Integrated Jail, together with 20 other detainees who were also confined in the MPD Station 1 jail. At the time of the inspection of the CHR, Your Honors, there were about 79 personnel detained in a lockup cell in Manila Police District Station 1, which only can accommodate a maximum of 40 at that time. So if you can see the situation, that it was overcrowded in that particular time. This was brought about by the directive of National Headquarters for the MPD, along with other district offices in NCR, to conduct one-time, big-time operations, a massive, intensified anti-criminality campaign because of the start of the ASEAN Summit. So at that time, sir, we are conducting several police operations, and the arrest for a 3-day period of the MPD was about 169 persons arrested. Pursuant to this, sir, our Internal Affairs Service has been directed by the Chief PNP to conduct an investigation on the possible liabilities and accountability of our MPD personnel, and I understand that the IAS has already completed its investigation. And also, we have been informed that the Commission on Human Rights has already filed a case against our MPD personnel for alleged violations of pertinent laws regarding the inspection of the lockup cell in Tondo before the Office of the Ombudsman. So that is the status of this case, Your Honor, as of this time.
Okay. Before any member will interpolate the Colonel Coronel, we would like to hear from Commissioner Karen Gomez Dumpit of the Commission on Human Rights as to your office position on the manifestations and the briefing informations provided by the Manila Police Director, Colonel Coronel. You are recognized, ma'am.
Thank you, Your Honors. We would like to just report, if I may quote our transmittal letter to the Honorable Conchita Carpio Morales, the Ombudsman, that in line with Section 13 of Republic Act number 6770 and Rule 1, Section 3 of the Rules of Procedure of the Office of the Ombudsman, the Commission on Human Rights, has respectfully transmitted the following matter for appropriate action and investigation of their office. In fine, the matter involves the discovery of a secret detention cell in Rahabago Police Station 1, run and manned by personnel of the Manila Police District under the command of Police Superintendent Robert C. Domingo. The discovery was made on the night of April 27 by a special team of the CHR. The entrance to the secret detention cell is a hole in the wall of the room of the station's drug enforcement unit, which was covered by an open shelf. In it, the CHR special team discovered the presence of 12 detainees, 3 of whom were women. The closet-sized cell, which is approximately 1 by 5 meters, is dark with no lights and windows and has one ceiling fan and only one male urinal, which forced the detainees to defecate in plastic bags. The detainees were discovered to have slept in sitting positions for lack of space and with no provision of beds, and that some had not eaten for days. Some detainees have also alleged that they were beaten and electrocuted with the use of a taser. There were 12 detainees inside. I won't mention the names of these detainees, Your Honor, but let me just take note and provide you with some information on the start or periods of their detainments. The first, there are 2 who have been detained since April 25. Please take note that we undertook our mission on the early evening of 27 April. There were some who were detained for 1 week, particularly 2 people, and then others were also detained for 2 days. The CHR special team discovered that the names of all 12 were not contained in the station logbook. Neither was the blotter found in the police precinct. We couldn't find it. Our investigators and our lawyers were asking for the log or for the blotter, and they weren't able to produce this. But through the station personnel, they stated that they were arrested, or these 12 were arrested for violations of the Comprehensive Dangerous Act of 2002. Some, however, were alleged to that they were arrested without any probable cause. The detainees also alleged that some police officers extorted money from them in exchange for their release, and that their families were not allowed entry into the cell or to see their loved ones. In sum, the CHR believes that there is sufficient cause for the Ombudsman to investigate the personnel of the Manila Police District Rahabago Police Station 1 involved for violations of the following provisions. Article 124 of the Revised Penal Code, arbitrary detention. Article 282, Revised Penal Code again, grave threats. Article 286, grave coercion. Article 294, robbery extortion, Sections 4A, 1 to 4, and Sections 4B, 3 and 11 of 9745 or the Anti-Torture Act. The police or personnel involved are also subject to administrative liability for the above-mentioned violations, as well as their violation of the 2013 revised Philippine National Police Operations Procedures, specifically Rule 13.6G, 20.1F, and 20.2. Finally, Your Honor, we'd like to state and quote the Office of the High Commissioner for Human Rights, a study on the secret detention cell. Secret detention violates the right to personal liberty and the provision or prohibition of arbitrary arrest and detention. People detained in secret detention cells are held outside the reach of law without the legal remedy or resort to legal procedure. Even if the detainees are criminally charged, the secrecy and insecurity caused by the denial of contact to the outside world and the fact that family members have no knowledge of their whereabouts and fate violate the presumption of innocence and are conducive to confessions obtained under torture or disappearance. Your Honor, as a last point, we'd like to provide this committee, this honorable committee, with a study on the human rights situation of police lock-up cells in the National Capital Region. This was published in 2015 following an inquiry into all PNP lock-up cells in the National Capital Region. Rahabago Police Station was included in this mission. And one of the particular recommendations that we gave was to actually, because there was a practice that blotters cannot be found in police stations, and we said that this must be corrected. This was a 2015 study, and I would like to also say that this study was conducted with a PNP, and in fact was actually sanctioned or welcomed by the National Capital Region Police Office in Taguig City and was signed by Carmelo Espina Valmoria, Police Director or Regional Director at the time, Your Honors. Our lawyers who were there present, who have personal knowledge of the discovery of the secret detention cell, are here present with me, Your Honors, and will be happy to answer your questions. Thank you.
Okay, thank you very much, Commissioner Dompet. Before any interpellations shall be made, the Chair would like first to recognize the representative of the PNP Internal Affairs Service, Police Senior Superintendent Francisco Gabriel Jr. on your office position on this particular event. You are recognized, sir.
Mr.
Thank you,
Chair,
Your Honor.
Mr. Chair, just short interjection.
Okay, what is that interjection?
Just a query, Mr.
Sarate.
Chair. Since this is an investigation in aid of legislation, aren't we going to require the resource persons to take their oath?
They were already under oath at the start of the committee hearing.
Okay, thank you, Mr. Chair.
Okay. You may proceed, Senior Superintendent Gabriel.
Your Honor, I would like to manifest to respectfully recognize our Acting Regional Director for Internal Affairs Service, National Capital Region, who are here with me to read first our opening statement before we proceed to our questioning.
Okay.
Senior Superintendent Romeo Santana, Your Honor.
Okay. Were you able to take your oath at the start of the hearing?
Yes, sir. Because I came here with the purpose of sharing our side, the ES.
Okay. As the highest officer present from the Office of the Internal Affairs Service, you are recognized.
Yes, sir. Good morning to our respectable, honorable members of the August body. Good morning, everyone. This pertains to the parallel investigation conducted by our service, the Internal Affairs Service, on the alleged secret detention cell and violation of Anti-Torture Act of 2009, as initiated and discovered by the Commission of Human Rights on April 27, 2017 at the Rahabago Tondo Police Station 1, Manila Police District. Allegedly, the Commission on Human Rights, led by Attorney Gilbert Visser, with members of the media, conducted a physical inspection at the MPD Station 1 in Rahabago Tondo Police Station on April 27, 2017 at about 6:30 p.m. Incidentally, they discovered a secret detention cell and detained therein were 12 persons arrested for violation of Republic Act 9165 or the Comprehensive Dangerous Drug Act of 2002. Thus, this inquiry, it is enshrined in our Constitution, Article 3, Bill of Rights, Section 12, Para 2, provides that no torture, force, violence, threat, intimidation, or any other means which vitiate the free will shall be used against any person. Secret detention places, solitary, incommunicado, or other similar forms of detention are prohibited. Likewise, in Republic Act number 9745, which is an act penalizing torture and other cruel, inhuman, and degrading treatment or punishment and prescribing penalties thereof, under Section 2, Para C, to ensure that secret detention places, solitary, incommunicado, or other similar forms of detention where torture may be carried out with impunity are prohibited. The Internal Affairs Service, as mandated by Republic Act 8551, Section 39, under motu proprio, Para B, incidents where death, serious physical injury, or any violation of human rights occurred in the conduct of a police operation. Thus, we conducted our own investigation as one of the fact-finding bodies of a PNP, and to prove the existence of the secret detention cell and whether there exists violation on human rights, to indict PNP personnel assigned at the MPD Station 1 of administrative charges. And on May 15, 2017, MPD IAS, as led by our District Superintendent, Senior Superintendent Gabriel, submitted the reports dated May 10, 2017. Initial investigation revealed that the alleged secret detention cell, as certified by the barangay officials covered by the area of responsibility of MPD Station 1, exactly 6 barangay chairman and 3 barangay kagawad, that the alleged detention cell is known to the place, is known in the area, and is being used as a temporary holding staging area for arrested suspects. And that based on the certification of barangay chairwoman Herminia R. Lumbad and other barangay officials of barangay of the said barangays, that family members of the arrested suspects are free to visit and inspect them at the holding area while waiting for proper inquest proceedings. In fact, we have gathered 5 sworn statements from the family members indicating therein that they freely visit their relatives on that area. On the alleged of torture, we have gathered medical results from the Hospital of Manila Medical Centers, and also we secure another medical test from the independent agency, the SOCO, or from the crime lab laboratory, from their medical legal, and found that there were the findings is that there are negative of torture. The condition of the MPD Station 1 was also put into scrutiny, and found that the building, during our ocular investigation, we found that the building is an old structure and is a very small facility to accommodate the intensive anti-criminality campaign of the PNP, most especially its drive on anti-illegal drugs. The station jail facility is designed to hold at least 40 males and 10 females. However, during the ocular investigation on April 28, 2017, the day after the CHR inspection, it contained a total of 86 detainees. This difficulty is shared by almost all of the PNP station jail facilities nationwide. Probably a part of this predicament can be attributed to the delay in the issuance of commitment order by the court to detainees before being transferred to the proper correction facilities. The Internal Affairs Service strived diligently to find more pieces of evidence and probable cause to substantiate filing appropriate administrative case against alleged violation of human rights, but to no avail. It appears that the reported alleged secret detention cell and other human rights violations are devoid of merit. Moreover, the CHR has taken first cognizance of the case and filed criminal and administrative cases against PNP personnel of MPD Station 1, headed by Police Superintendent Robert C. Domingo, before the Ombudsman, thereby acquiring jurisdiction, rendering this service without proper authority or jurisdiction, hence unable to continue a deeper investigation to prove other possible violations of police operational procedures. This service, pursuant to the subpoena duces tecum issued by the Ombudsman, have submitted our collated documents pertaining to this instant case last May 16, 2017. In closing, the Internal Affairs Service and the PNP in general fervently hopes and recommends the upgrading of PNP detention facilities, particularly at the police station level. We would like to encourage the Human Rights Commission to conduct regular inspection on all police stations to see for themselves the dilemma that our working PNP personnel is facing as of this moment, and for their much needed recommendation for the improvements of our detention facilities. That's all, sir.
Okay, thank you very much. Now, I'd like to ask a question to Chief Superintendent Joel Coronel. The chair would like to apologize for the error in addressing your rank earlier. Do you agree that this specific detention cell be called as secret detention cell as manifested by the IAS and that of the CHR? Chief Superintendent Coronel.
Yes, sir. If I understand the question, Your Honor, do I agree if this detentions or lockup cell is a secret detention cell?
Yes, as being called by the CHR and that of the IAS in their respective positions.
Thank you, Your Honor. With due respect to the comments made by our Commission on Human Rights, as manifested by also in the report of our IAS and statements given by no less than the barangay chairman themselves who are located in that particular police district in the jurisdiction of that police station, have all indicated that that lockup cell is not a secret detention facility. The persons who were brought in there for investigation after being arrested for commissions of crime are not held incommunicado. They were allowed to be visited by their relatives. In fact, some of the relatives have brought food and clothing to them at the time of their temporary detention. And in fact, members of media have come to visit that particular area in various times in the past, even before the visit made by the CHR, and are all aware that this lockup facility exists. It was a temporary holding area for those persons who were arrested by Station 1 for drug offenses prior to the filing of cases before the City Prosecutor's Office, Your Honor.
In the year 2015, where were you assigned? Are you already the Manila Police Director?
No, Your Honor, I assumed as District Director of the Manila Police District on July 1, 2016.
And you have heard the manifestation of Commissioner Dompit from the CHR that sometimes in 2015 there was that study of this secret detention cell in Metro Manila, and that this particular police station of the Manila Police District was included in the list. Do you are you aware of such study insofar as your office is concerned?
Yes, Your Honor. I have even a copy of the study made by the Human Rights Commission together with the NCRPO, made sometime or published sometime April 2015, indicating therein the condition of the different lockup cells in different parts of Metro Manila, not only in the Manila Police District and in Rahabago Station 1. That's why I'm sure that the Commission on Human Rights is well aware of the deplorable and unlamentable conditions of prisoners at the time when the study was made, even existing to the time when that inspection or surprise visit was made by the CHR, particularly in light of the double barrel campaign launched by the PNP starting July 1, 2016, wherein arrests made by the Philippine National Police have nearly doubled because of the intensified campaign. So I don't see any reason why the CHR would express surprise, dismay, or shock in knowing that the number of detainees in different lockup cells in Metro Manila alone have nearly doubled, and most especially the conditions of these detainees, I'm sure, are all, I would say, very unfortunate and unlamentable, considering that of the substandard or subhuman conditions they are now staying in that particular cells, Your Honor.
Okay. Now, since you were aware, what actions did you do insofar as this particular congestions in this particular detention cell? Did you make any recommendation to higher authorities to do something in order to improve the condition of this detention cell?
Yes, sir. In several command conferences held in Camp Crame, the last of which was last February, we have brought to the attention of our national headquarters the condition of our lockup cells, the overcrowded and congested cells. In fact, I recommended possibly for appropriation of additional or the release of additional funds for the expansion of our detention facilities or construction of new lockup cells. And in fact, also directed our subordinate commanders here in the Manila Police District to coordinate with the respective courts where the cases of the detainees are being held, to issue the requisite commitment orders, Your Honor, so that these detainees can be transferred to the city jail as soon as possible time.
Okay. Police Director Abayalde, you have heard the recommendations made by Chief Superintendent Coronel that was even prior to this incident. May we know if that recommendation reaches to your office, and if it reaches to your office, what was the action taken by your office?
Yes, Your Honor. Actually, we have made requests to the different courts also to expedite the issuance of commitment orders. But then again, we cannot pressure these courts, Your Honor, to issue court orders, because they also take into consideration the congested regular city jails already, particularly here in Metro Manila also.
Aside from that action of communicating with the courts, is there no other actions like improving the detention cell or expanding it in order that it should not be as deplorable as manifested by the commissioner of the CHR?
Well, Your Honor, some of the detainees are transferred to the temporary detention cell also located in Camp Bagong Diwa. But then again, because of the drug war on drug that was launched on July 1 last year, where our detainees were doubled, no, inside the detention, we could not also accommodate other detainees also inside our camp because it's already congested also, Your Honor. What we directed the different for the different police chiefs of police is to coordinate with the local government units to possibly expand or improve the detention cells of the different police stations, or probably expand the police stations in the different cities and municipalities.
Okay. And these recommendations which reached to your office, did this recommendation also was forwarded or elevated to the Philippine National Police headquarters at Camp Crame for whatever appropriate actions that they can do insofar as the recommendation of your subordinate is concerned?
Well, Your Honor, I'm sure the national headquarters is well aware, very much aware of this congestion. But then again, this entails funding, Your Honor.
Yes, but in short, there was no action by the central office, by Camp Crame, insofar as these deplorable conditions of the detention cell because of the absence of funding. Because I remember right, during the last budget hearing, all the budget which were asked by the Philippine National Police through your very popular PNP chief was granted by this House of Representatives. And I cannot recall of any request from the Philippine National Police of any funding to improve the deplorable conditions of our detention center, because this detention center is within the jurisdiction of the PNP, not with the local government or not with the Bureau of Jail and Management. So that is what we are concerned now on how to improve these facilities. So how does Congress could give you the required funding assistance if you are not also requesting? So we would like to know if what was the action taken by your general headquarters on this particular matter?
Your Honor, the overcrowding of detention cells was only manifested the last quarter or the last quarter of last year, where the budget was already, I think, was already deliberated, and most of the time our budget only is purposely for the construction of additional police stations, not for the improvement or expansion of detention cells.
Okay, before I yield the floor to Deputy Speaker Castro, I would just like to inform the good General, Police Director Abayalde. The other month, I had a visit at the office of the DBM, although police budget was not my concern at that time, but I came to know that you still have pending allocation of 100 million for your capital outlay that until this time has not yet been touched. That's why I was asking you that question, if there was that action taken by the national headquarters, so that through this committee hearing, you can convey it to your PNP chief about this information, that until today, you still have 100 million untouched capital outlay, which can be used to improve deplorable detention cells. Okay? Now, Deputy Speaker Castro is recognized as the first to interpolate.
Thank you, Mr. Chairman. I would like to ask Chief Superintendent Joel Coronel, am I correct?
Yes, Your Honor.
Good, I am correct. You said a while ago that this detention cell is not secret. May
Yes,
I know
Your
from you, Chief Superintendent, when was the first time that you ever discovered that there is a cell or a lock-up cell in Rahabago
Yes, sir.
prison?
Yes, sir. The last time I saw that particular lockup cell was sometime early March of this year when I visited Police Station 1. Among with the different police stations in Manila, sir, as part of my duties. And I was informed by the station commander, Superintendent Domingo, that particular room, which was then used as a storage room prior to it was converted to a lockup cell. The same room was being used by a storage room of the MPD, was converted into a temporary holding area in order to alleviate the congestion in the regular jail of Station 1. And for these particular reasons, all those who have just been arrested and now subject to arrest and booking procedures prior to inquest proceedings are brought to that particular facility
Mr. Chairman,
in
I'm
temporary.
not asking other matters to you, Chief Superintendent. I was only asking you, when was the first time that you knew of this detention cell? That's my question.
I'm sorry, Honor. Last March, sir, when I visited the police station.
When were you assigned Manila?
I was designated as the district director on July 1, 2016, Your Honor.
How many months prior to your knowing of this detention cell?
I understand based on the report of the superintendent.
No, I'm asking you. You said
Yes, Your
that
Honor.
you were assigned July. If you know how to count, how many months was that before you discovered this detention cell in March? How many
Yes.
months?
Yes, sir. I learned of that facility personally when I visited it on March, sir. Early part of
And you
March this
said
year.
you were assigned in Manila, July.
Yes, Your Honor.
Therefore, how many months prior to your discovery were you assigned in Manila?
Sir, according to Station 1, the
No,
temporary
I'm asking
lockup cell
you.
was just put up last February.
Ilang buwan ka na
Yes, sir.
sa Manila bago mo na-discover itong detention cell?
I was already 7 months as district director
7
at that
months.
time. Yes, Your
And
Honor.
you have been there for 7 months, and it was only on March that you discovered this detention cell.
Prior to March, sir,
No,
I had
you
my previous
answer me
visits.
yes or no.
Yes, sir. Only on March, Your Honor, I was informed of that.
With your discovery of this detention cell, 7 months after you were assigned in Manila, would you tell us whether you were performing your duties as head of the Manila Police Department?
Yes, I would like to believe, yes, sir. I am performing my duties to the best of my abilities.
Notwithstanding that you discovered that only after 7 months?
I
I
understand, sir.
am not after
Sir.
what you believe.
Yes, sir.
I am after you answer us correctly.
Yes, sir. May I be allowed to explain, sir?
No, you just answer my question
sir.
first.
Yes, sir. The lockup cell, sir, was established only February this year, sir, by Superintendent Domingo, based on his report that to address the over-congestion of the Station 1. So that's about a month after the establishment of that lockup cell was I able to inspect that particular station, Your Honor.
You know, Chief Superintendent, you were telling us about congestion. You were already in Manila for 7 months, and it was only in March that you learned that there is congestion in that precinct?
No, Your Honor. I'm aware that congestion already exists as early as fourth quarter of 2016.
Therefore, you should not give us that reason that you wanted to address the congestion there. Because you discovered that 7 months prior, no, 7 months after you were assigned in Manila. Now, second question. You said that you learned of this congestion even before it was discovered in March 2016. And upon discovery of this congestion and lockup cell, Domingo, who was the head of the precinct, and others were relieved. Why only in March did you relieve Domingo and et al.?
No, sir. I relieved Domingo and the others only on April 28, after the visit
Why
of the
only in
CHR.
April?
It was to pave way for an impartial and objective investigation so that he will not be able to unduly influence
You
the
said
conduct
that
of
this is
investigation.
not a secret cell. If the purpose is to conduct an impartial investigation, and you already learned that this is not a secret cell, why would you spare these people? Why would you relieve these people when you already know that this is not a secret cell?
Yes, sir. The order of relief for Superintendent Domingo and the others was given to me by my superior so that on their instructions, I ordered their relief on April 28, 2016, Your
I
Honor.
said, you are going to relieve or even recommend the relief of this Domingo et al. when you yourself know that there is no secret cell?
Sir,
Why?
that was the order given to me to order for the relief.
Are you telling this representation that notwithstanding that the order is not correct, you will not explain to your superior that the order should be recalled, considering that it is not proper, since there is no secret cell?
Sir. Yes, sir. I have submitted a report on that position, Your Honor, to my superiors for their deliberation.
Report is different from recommendation.
Yes, sir.
That order should be recalled. Now my question is, you said that there is no secret cell. You said that Domingo was relieved. Why would they be relieved when they're not committing anything illegal?
Because at the time, sir, an investigation was ordered by the Chief PNP.
Why
and the
would
Regional
you
Director.
investigate when there is nothing to investigate, considering that you know that this is not a secret cell?
Yes, sir. Considering that the controversy generated by that particular incident, Your Honor, I think it was prudent on the part of PNP leadership to order the administrative relief of Domingo et al.
Is that an
pending
SOP that notwithstanding that you know that there is nothing wrong and your people did not commit anything illegal, you will still order the relief of those?
Yes, sir.
Where?
That's part
Can
of
you
the
show that
directive. It's
in
part
the
of
standing
our-
operating procedure of the PNP?
Yes, sir. It's part of our policy incorporated in our internal disciplinary
Can you show that to us?
procedures. Meron ba tayo ng ano? Yung administrative relief? Yung policy on administrative relief? Sir, if I may be allowed to ask my colleagues for that particular policy.
Okay, go ahead, General.
How many minutes will it take you to answer that question? May we request the Honorable Castro to ask another question pending Coronel's research of an appropriate answer?
Initially, Mr. Chairman, I don't even believe that there should be a research, because being chief superintendent, it should be in his fingertips.
That's why.
And I am surprised that he cannot even pinpoint outright the basis of his answer, that is provided for in the standing operating procedure of the PNP.
That's why, Honorable Castro, if we could go to another question, because it seems that Superintendent Coronel cannot answer your question.
Now, Mr. Chief Superintendent Coronel, before you answer that question, there is a finding that the inmates or the people detained in that cell were not included in the blotter. There is a finding to that effect. My question is, why were they not included in the blotter of the police precinct?
Yes, Your Honor. I understand that there was an allegation that were not included in the blotter. But based on the report submitted by Colonel Domingo, he informed me that the arrest of these persons were incorporated in our spot reports, journal, and in our investigation report form, Your Honor, which also stands as our blotter in our procedures.
That report, which will show that indeed those detained in the cell were listed or were reflected in the police blotter of the precinct.
Your Honor, may I be allowed to furnish the copy to the committee on the spot reports prepared by Station 1, then Station Commander Domingo, regarding the arrest of the persons mentioned in the CHR report, Your Honor. Pwede kong bigay na? Bigay na natin.
Chief Superintendent Coronel, do you understand the difference between a spot report and a police blotter?
Yes, Your Honor.
You are giving me copy of the spot report, but you are not presenting to us.
The blotter is in the one in handwritten form, Your Honor, the one incorporated by
Isn't it that police blotter looks like a book in the police precinct?
Yes, Your Honor.
This is not one.
It's a photocopy of the entries in that blotter, Your Honor.
How do I know that this is an authentic?
We can bring the original blotter
Next
in the
time
next
you
hearing,
bring
Your
it.
Honor. Yes, Your Honor.
Now, going back to the same question, have you completed your research?
Which concern you?
You said a while ago that you were trying to consult your records or even your materials. That a police officer or any of the members of the PNP assigned in a station may be relieved from their duties, notwithstanding that there is clear evidence that they are not or they have not committed anything illegal.
That particular issuance made by the PNP is issued by then Chief PNP General Raul Bacalso on January 10, 2011, which provides for the guidelines on accountability of immediate officer or his subordinates in cases of administrative and criminal violations. It is provided for that the immediate officer shall immediately relieve on the presumption of negligence if his subordinate are involved in offenses where he was not able to take corrective or preventive action. So the administrative relief of Colonel Domingo, Your Honor, is just an administrative measure to ensure that in the course of an investigation that will be conducted, he will not be unduly
You
influenced.
are going too far,
Yes, sorry, Your Honor.
Chief Superintendent Coronel.
Print na lang.
Because by simply reading that, you mentioned presumption of negligence. Here, negligence is not involved. Remember that. Negligence is not involved. Are you going to insist?
Ano? In that case, Your Honor, I submit to the position of the honorable member of this Congress.
No, we don't have any discretion here. We are asking you what really happened.
Yes, sir.
Why would, if there is no secret cell, why would Domingo and company be relieved when evidently, clearly, pristinely, they have not committed something illegal?
Yes, sir. First of all, sir, because of the allegations made by the CHR, which will need to be investigated. And second, upon the instruction of my immediate superiors to order the relief of Colonel Domingo and his men so that investigation will be conducted.
Can you not investigate
Your Honor.
even if they are there?
Yes, sir, we can investigate this
Why
incident.
go to the extent of relieving them?
Upon the instruction of my superior officers.
Are
and
you
also-
telling me and are you telling the members of this committee that simply because of the instruction of your superior, even you know that the instruction is not correct, you are going to implement that instruction?
Yes, sir. At the time I
Have
issued...
you ever called the attention of your superior?
Yes, Your Honor.
Who is your superior?
Director Oscar
Are you
Albayalde,
telling
Your Honor.
us that General Albayalde continued to enforce his order, notwithstanding your explanation and your recommendation that Domingo et al. Did not commit anything wrong?
Yes, Your Honor. He gave me the instructions to order the relief, which I complied with as a subordinate commander.
Did you
Your Honor.
call his attention?
Yes, Your Honor. I informed
Meaning
him
to
of
say,
this particular
you are
situation.
telling now that General Albayalde continued to enforce that order, knowing that that was not necessary and upon your recommendation.
Yes, Your Honor. I informed
Where
him
did
of
you
that.
place your recommendation? Is it verbal or in writing?
At that time, sir, of the relief of Colonel Domingo, it was verbally made because I was present when General Albayalde gave me that particular
Are you
instruction,
telling me
Your
that
Honor.
General Albayalde will simply heed a recommendation verbal without anything to hold on?
Yes, in our practice, Your Honor, that is
Practice?
also allowed in our.
That kind of practice is tolerated or even allowed in the PNP?
Yes, Your Honor.
Don't tell me that that is a practice. And are you governed only by practice, not by established standing operating procedure?
Yes, Your Honor. We are governed by rules and regulations, and
Therefore,
also.
it's not included in your SOP.
No, sir. That's not part of our SOP.
You are toying a very dangerous proposition here. Don't tell us and do not give us the impression that will generate an impression on our part that we have this kind of police officers.
Before the Chief Superintendent Coronel will respond to it, I would like to rephrase the Honorable Deputy Speaker to wind up because we still have a lot of interpellators. Probably in your second round, you can pursue some good points which you want.
It will take,
to drive.
Mr. Chairman, thy kingdom come to finish this interpellation, and I will dig deeper. But for the benefit of the other members of the committee, simply to give them the opportunity to interpellate, I am withdrawing my interpellation now, subject to continuation, Mr. Chairman.
Thank you very much, the Honorable Deputy Speaker. Before we will proceed, the Chair would like to acknowledge the presence of two distinguished colleagues, handsome gentlemen from the province of Cebu, the Honorable Wilfredo Caminero and the Honorable Representative Peter Jan Calderon. The Chair would like now to recognize the Honorable Representative Gonzaga.
Thank you, Mr. Chair. Is Superintendent Domingo around? Will you please find a seat because you will be the one I will be asking Sir Domingo.
The Honorable
Yes, sir.
Gonzaga, before you will proceed, Committee Secretary is Superintendent Domingo was included in the swearing a while ago. So
Nakapag-out po ako, sir.
you were under oath
Yes, sir.
earlier?
Yes, sir.
Okay. Thank you very much. The Honorable Gonzaga, you may proceed.
Thank you. Sir Domingo, it appeared that you were in charge of the Rahabago MPD.
Yes, sir.
Figures would present that there were 12 detainees when the CHR discovered this what we call secret detention cell.
Sir, yes, sir. Yes, sir. Yes, sir. Sir, tatlo po yung nasa labas na, sir. Yung siyam po ang inabutan, sir, dun sa loob, sir, nung staging area namin, sir.
Ilan yung babae doon sa loob, ilan yung lalaki nandun sa what we call detention cell.
Sir, yung, Your Honor, sir, yung babae, sir, nasa tatlo po, sir.
Tatlo. Anong kaso ng
Sir,
mga...
dalawa po, sir, dalawa.
Dalawa.
Sir, dalawa, sir.
So, 7 na lang yung lalaki na sa loob.
Bali, sir, ano po, 10 po, sir, 10.
Sabi mo...
Siyam, sir, siyam. Dalawang babae, sir.
Sabi mo kanina, siyam ang nasa loob,
Sa loob,
tatlo
sir.
yung sa labas.
Sir, hindi, sir. Yung, sir, ulitin ko, sir. Kasi, sir, yung dumating po, sir, yung ating pong CHR, sir,
Meron na po kasi kami short na tatlong unang nahuli, sir, na for inquest na, sir.
Kaya nga tinatanong ko yung siyam.
Yung
Huwag
siyam,
mo na
sir,
isabi-
yung siyam, sir, dalawa po yung babae, sir. 7 po yung lalaki, sir.
Kaya nga sabi ko, sa
Yes, sir.
dalawa, babae,
Yes,
7
sir.
yung
Lalaki,
lalaki.
sir. Oh, yes, sir.
Yung
Lalaki.
dalawang babae, anong kaso? Bakit nyo sila hinuli?
Sir, it was the result of our anti-criminality operation, sir. Pat session, sir.
Pat session.
Yes, sir.
Ano nga kaso?
Violation of Republic Act 9165, sir.
Ang haba-haba ng 9165. I'm a lawyer.
Sir,
ikaw yung pulis eh. Anong kasong isinampa mo sa kanila?
Sir, pat session nga, sir. Ano yun? Sir, hindi ko na po, sir, sir, basta, sir,
Anong kaso? Yung pat
Sir,
session?
pwede ko bang makita, sir, dito, sir? Sa record ko, sir.
Okay,
Sir,
Superintendent
can I
Domingo.
consult my record, sir?
Yeah, Superintendent
Sige, sige,
Domingo, you can verify on your records
Yes, sir.
so that your records could assist you in
Yes, sir.
giving a responsive answer to the question of
Yes,
the
sir.
honorable members of this committee.
Your Honor, sir. Yes, opo, Your Honor, sir.
Sige, tingnan mo. Anong kaso ng dalawang babae?
Si Grace.
Use?
Sir, yung yung April 26, sir, si Grace De Guzman, sir, violation of Section 11, sir.
That's use.
Hindi, sir, possession, sir.
Possession. Ang isa?
Possession, sir. Sir, si Sweetie, sir. Sir, sandali lang, sir. Iniisa-isa ko po yung record ko, sir.
Okay, relax lang.
Opo, sir.
Dahan-dahan, isa-isa.
Dahan-dahan lang, sir.
Importante, accurate yung sagot.
Kaya po, sir. Dahan-dahan lang, sir. Sir, si Grace De Guzman, sir, Section 11, sir, si Narcisa Dalisay, sir, Section 12, Your Honor, sir. Section 12 po, sir, si Narcisa Dalisay, Your Honor, sir. Saka po, sir, si Swedy Guilieno, sir, Your Honor, sir.
Dalawa lang yung babae sinabi mo, di ba? Bakit na tatlo na yan?
Sir, tatlo, sir. Yung isa kasi, sir, nasa labas, sir.
Hindi, wag mo na yung... just answer my question. Kailan nahuli yung pangalawa? Kailan yung nahuli yan? Yung
Sir,
isa...
sir, yung una, sir, yung una po, sir, si Narcisa Dalisay, sir, nahuli po namin to, sir, ng April 27, sir.
Si Grace?
Si Grace De Guzman, sir, nahuli po, sir, namin ng April 26, sir.
Okay, so hindi ito pat session. Kasi possession to.
Opo, sir, possession po pala.
Okay?
Yes, sir, possession po.
Yung isa naman, paraphernalia.
Opo, paraphernalia
O saan
po.
doon yung pat session dyan?
Sir?
Saan yung pat session dyan?
Sir, kasama kasi sila, sir, sa grupo, sir, na yung iba, sir, yung kasama sila kasi, sir, sa isang grupo, sir, ng huli, sir, na during the anti-criminality operation, sir, na sila, sir, ng tropa namin, sir, yung iba, sir, nag-positive, sir, sa illegal drugs, sir. Yung iba, sir, illegal, sir, possession of paraphernalia, sir.
Saan yung iba? Grupo to sila, grupo, di ba? Sabi
Yes, sir.
mo,
Yes, sir.
grupo.
Opo, sir.
So
Grupo,
ilan
grupo.
yun sila lahat-lahat?
Bali, sir, yung April 27, sir, 10, sir, ang aming na-inquest doon, sir, eh. Nung April 26, sir, 3.
Okay, so ito na lang nandito, ha?
Opo, sir.
Ito, yung 7, lalaki to, di ba?
Opo.
Anong kaso ng 7 na lalaki?
Sir, yung mga Sir, yung April 26, sir, pwede ako magsimula doon, sir, sa April 26, sir.
Basta mga lalaki,
sige, sir.
okay.
Sir, si Sunny Iglesias, sir, Section 11, sir. Si Narciso Canlas, Section 5 and 11.
Para
Tapos, sir,
maintindihan ng mga mamamayan,
sir, ulitin ko po.
sabihin mo kung anong kasalanan.
Opo, sir.
Hindi yung section.
Sir, ulitin ko po, sir. Sir, si Sunny Iglesias po, sir, yung Section 11, sir, ano po?
Possession.
Possession po, sir. Possession
Kailan
of
mo nahuli?
illegal...
Kailan mo nahuli?
Sir, yung sa Iglesia, sir, sir, 26 April, sir.
Okay. Narciso.
Si Narciso Canla, sir, April 26 din, sir, nahuli.
Okay. Sunod.
Sir, yung Grace de Guzman, sir, April 26 din po nahuli.
Babae naman.
Babae na pala yun, sir. Tapos na pala yun, sir. Tapos na pala yun, sir. Sorry, sir. Sorry, sir. Lalaki na pala, sir. Lalaki na.
Baka ang tingin mo sa lalaki, babae pa rin.
Hindi, oh, sir.
Mr. Chair,
Your Honor, sir.
Mr. Chair, may I interject?
The Honorable Romeo Acop, what is the interjection?
I would just like to manifest, Mr. Chair, having been once a member of this organization, kung ganyan po ang mga station commander natin, Attorney Jigs and Director Abayalde, what would you do? You know, alam po natin na yung commander is responsible for whatever his unit does or fails to do. If that is the kind of station commander and I'm the regional director, without any reason, because of that alone, I would have relieved him. Napapaya na ako rito eh. Thank you, Mr. Chair.
Okay, the manifestation of the Honorable Acop is duly noted. I
Sige.
wish that the police director of NCRPO who heard the manifestation should also take into consideration the noble manifestation of the Honorable Acop. Okay, Superintendent Domingo, go ahead. Just be responsive to the question.
Yes, sir.
Huwag mo dagdagan, diretso lang, at huwag kang kakabahan. Hindi ka naman kakainin ni Honorable Gonzaga. Mabait ito from Davao del Norte.
Sir, Sir Carlito Garcia, sir, possession of illegal possession of paraphernalia, sir.
Kailan nahuli?
And possession of paraphernalia during parties and social gatherings or meetings. Saka, sir, section 15, sir, use. Si Chester Garcia, sir, possession of equipment, apparatus, paraphernalia. Section 14, sir, possession of paraphernalia during parties, social gathering, or meeting.
Kailan nahuli si Chester?
Sir, 27 na po, sir.
Next, apat pa yon.
Yes, sir. Si Jervin Perez, sir. Section 12, sir, possession of equipment, apparatus, and paraphernalia, sir.
Kailan nahuli?
Sir, 27 din po, sir.
Next.
Jonard Repran, sir. Section 12, sir, possession of equipment, apparatus. Section 14, sir, possession of paraphernalia during parties, social gathering, or meeting, sir. And Section 15, sir, use.
Kailan nahuli?
Sir, 27 din po, sir.
Ang last?
Yes, sir.
Sino yung last?
Si RJ Balingit, sir. Section 12, sir, possession of equipment, apparatus, paraphernalia. Si Robert Moro, sir. Section 12. Ganon din, sir, possession of equipment, apparatus. Tapos, sir, sa Cesar de Guzman, Section 12, sir, possession of equipment, apparatus, paraphernalia. Si Arman Andal, sir, Section 12, possession of equipment, apparatus, paraphernalia. Sir, that's all, sir.
Okay. So, lahat sila nahuli 26, April 26 and 27.
Yes, sir.
Na-discover ng CHR on April 27.
Yes, sir.
So, merong investigation conducted when you were ordered relief.
Yes, sir.
The investigation took place.
Yes, sir.
Yung investigation nagsasabi na wala ho kayong ginawang masama because this is not a detention cell as certified to by barangay officials.
Yes, sir.
Wala naman daw torture because merong medical test, correct?
Yes, sir. Opo, sir.
So, aside from that, meron pa bang mga charges under the investigation? Na-charge kayo ng detention cell, secret detention cell, torture. Meron pa bang report under the investigation aside from having a detention cell and this what we call torture?
Yes, sir. Sir, Sir, wala pa po kaming... Sir, sa ombudsman, sir, pinailan na rin, sir, kami, sir.
Hindi, sa investigation.
Sa amin, sir, sa...
Di ba may cleared na kayo sa investigation?
Yes, sir.
So anong yung charges doon sa investigation? Anong clear sa inyo sa investigation?
Sir, yun, sir, yung sa secret detention cell, sir.
At saka doon sa walang torture.
Yes, sir,
Okay.
walang torture, sir.
Ang sabi ni Chief Superintendent Coronel, it existed, the detention cell existed on February 2017.
Yes.
Do you agree?
Yes, sir.
Ikaw ang gumawa nito.
Opo, sir, may initiative, sir.
Dahil ginawa mo ito, dahil sobra na ang mga detainee sa lugar mo.
Opo, sir.
Okay. Thank you, Mr. Chief Domingo.
Yes, sir.
I would ask this Chief Superintendent Coronel, please, sir.
Yes, Your Honor.
Who conducted the investigation?
Your Honor, upon the instructions of our Chief PNP, our Internal Affairs Service was the one directed to conduct the investigation relative to the allegations. The Internal Affairs Service, Your Honor.
I am asking who? Office yung sinasabi mo.
Particularly our head of ES present here right now, Senior Superintendent Santa Ana and Senior Superintendent Francisco Gabriel,
Okay,
Your
I
Honor.
will be asking the conducting investigating officer, Senior Superintendent Santa Ana. Okay. Sir, andyan sa report mo, di ba ikaw yung nagperma ng report? Okay. Sa report mo, sinabi mo na walang secret detention cell at walang torture, di ba?
Yes, sir.
Wala na bang iba na ni-report mo aside from those mentioned earlier?
Your Honor, wala na po. Maliban sa, we focus on that alleged secret detention cell and torture
Okay.
on our investigation.
May aligasyon na nanghingi ang pera para ma-release, may aligasyon na nanghingi ang pera yung mga pulis. Hindi mo ba sinali sa report yan?
I would like, based on the report of the district superintendents, wala naman, sir, hiningi yung mga kwan.
Hindi, sa report mo. Sa report mo, kasali ba yan? Did you conduct an investigation on that aspect?
Not yet, sir, because we have focused our investigation on the torture and secret detention
So
cell.
meron pang sunod na investigasyon?
But,
Wala na.
Yes, sir, but it has been overtaken by events because the CHR has already filed criminal administrative case to the personnel.
Okay. According to you, you conducted the investigation. You, of course, you conducted an ocular inspection. You visited
Yes,
the
sir.
site, the
Yes, sir.
detention cell. Ito bang detention cell, sa human condition, is it above par or subpar based sa human condition?
Based on the both detention cell, the regular and this alleged secret detention cell, they are below par because of the congestions.
Regardless of the congestions, kung isa lang doon sa regular cell, isa lang doon sa they call detention cell, ito bang detention cell above ba sa human condition? Papasa ba?
Insofar as the based on investigation, if only that place is clean and with complete facilities, papasa yon. But for this,
alam mo, sir,
yes, sir.
sabi mo if ang tanong ko naman, papasa ba ito? No ifs and no buts. Papasa ba? Is it above?
Your Honor, pwedeng pumasa po ito as staging area only.
As
staging area. Holding area.
Detention cell nga ito, di ba?
That is what is alleged by the CHR, sir.
No, it's not you curtailed the freedom of that person. You curtailed. When you curtail the freedom of the person, he is a detainee. And because he is detainee, the place where you put a detainee is a detention cell. Now, ang tanong ko, ito bang detention, hindi ko na nga sinasabing secret detention cell, ito bang detention cell, above par ba siya sa human condition?
It's below.
Below?
Below, yes.
Okay.
Your Honor.
When you made that report, did you include that in your investigative report, that the detention cell is below par, the human condition? Ikaw nagawa, bakit ka pa nag...
Wala, sir. We did not include that.
You did not?
Include that.
Nobody called your attention that our Constitution says that facilities, detention cell facilities should be above human conditions. And that is included in the Article 3, Section 19, Paragraph 2 of our Constitution. Take note of that. And that should be included in your report. Okay? So this is below par, the human condition. Huwag kang magnad kasi we are, records purposes sabihin mo.
Yes, sir. Your Honor. Yes, Your Honor.
Okay. So, that violation, that glaring constitutional violation is not included in your report.
Yes, Your Honor.
Okay. So, Mr. Chair, Mr.
Santa Ana.
Chief Superintendent Santa Ana, ang lahat na sinabi ni Superintendent Domingo, nahuli lang on April 26 and 27. Ano ba ang totoo? Meron bang nilagay na meron ba kayong detainee dyan na nahuli pa noong April 20 or April 15?
Your Honor, based on the records and blatter, wala naman, sir, na silang nakalagay sa records na nahuli on 20th.
So,
as part of those 12 detainees.
So, ang kinakailangan natin dito, yung logbook, yung blatter of your office. So, meron kayong sinabmit kanina na excerpt or photocopy. Sa photocopy ba, nakalagay lahat itong sina Grace, sila Narcisa, sila Narciso, sila RJ, nakalagay ba doon na April 26 and 27 sila nahuli?
Yes, Your Honor.
And I will be reminding you, you are under oath.
Yes, Your Honor.
Okay.
With the kind indulgence of the Honorable Gonzaga, can you please wind up?
Yes, sir.
Thank you.
I will be asking the Commissioner of the CSR, Ma'am Karen. There was a report. Ang nakalagay sa report nyo, may dalawang nahuli na 2 weeks na sa bilangguan na what we call detention cell. Totoo ba ito?
Yes, sir. This is based on the interview that was conducted by our lawyers and our investigators who were there, Your Honor.
Nakasabi ho dito na for 7 days, dalawa yung nakakulong na for 1 week. Sino-sino po ito?
Hold on, sir. Andyan. Yung 1 week po, 1, 2, 3, 4. Apat po ang nakadetain for 1 week already. Arman Andal, Robert Muro, Cesar de Guzman, RJ Balingit po.
Yung apat sila, puro lalaki.
Opo.
Itong 2 days, sino-sino po itong 2 days na nabilanggo na? Sa report nyo, merong
apat din po.
Sino ho sila?
Narcisa Dalisay, Jonard Refran, Chester Garcia, Carlito Garcia, and Jervin Cahucom Perez, na sinabi 2 days siya, hindi siya nagbigay ng specific date. Babalikan ko lang po, Sunny Iglesia and Grace de Guzman since April 20 ang sinabi po sa kanila. Sinabi po sa aming mga lawyers.
Were you able to extract an affidavit from these detained persons that indeed they were detained for 2 weeks?
Not yet.
1
At
week?
that moment po, we were not able to do it because our major objective was to uncover the secret detention
Okay,
cell.
thank you.
But we do have recordings of of our investigation, in the course of our interviews, there are some
Okay.
recordings that have
Okay.
been taken by our investigators as well as our lawyers, Your Honor.
Mr. Chief Superintendent Santa Ana, sabi ho ng CHR, meron ng 2 weeks, meron ng April 20 na detain, meron ding 1 week na na-detain. Ang sabi mo, ang sabi ninyo, 26 and 27 lahat. If it is this true, bakit hindi ka nag-conduct ng investigation with regard to the period of being detained by these persons? Alam niyo po, meron tayong RPC. Alam niyo ho ito, this is the Article 124 of the RPC says, kung lalampas ho kayo ng 18 days, 12 hours, 18 hours, 36 hours in case of afflictive penalties, 36 hours in case of correctional, 18 hours in case of light penalties, 12 hours, ay subject na ho kayo ng arbitrary detention. Sinali ho nyo ba sa report dyan?
The Honorable Gonzaga.
1 minute, sir.
One more question, please. Thank you.
Your Honor, based on the gathered records, the 12 suspects detained were recorded on the blotter on the dates of 26 and 27. Therefore, for that complaint with regards to the period of time, longer period of time, I don't know if because these names are already included on that 26 and 27 blotter.
Okay, thank you. Ma'am Karen, will you please give us the pertinent documents as to the issues that I have raised before this committee with regard to the affidavit of the persons detained for since April 20 or 7 days prior to the discovery. Now, my last question is, did you include in your complaint before the Office of the Ombudsman with regard to violation of Article 124 and Article 125, delay in the delivery of detained persons to the appropriate court? Did you include that, Ma'am Karen?
124, yes, Your Honor. 125, it's also included. No, it's not included. 125 is not included.
Kasi pag na-detain ka ng April 20, discovered nyo 7 days, it's really a violation of Article 125. So kindly submit the necessary documents before this committee for our perusal. So lastly, Chief Superintendent Santa Ana and Chief Superintendent Coronel, please give us a certified true copy or an excerpt copy of the police blotter with regard to this aspect. Thank you.
Thank you very much, Honorable Gonzaga. The Commission on Human Rights through Commissioner Dompit is directed to submit to this committee the documents required by the Honorable Gonzaga within 1 week or 10 days from today.
Your Honor, we have a copy, a certified true copy of our report that was submitted to the Ombudsman, which is now regarded as the complaint. We also have several affidavits, including the ones who have investigated, as well as 2 additional or 3 affidavits of those whom we interviewed.
Yeah, that's why the chair
Yes, sir.
is asking you to please furnish a copy of that.
Today, sir, after
Okay.
this hearing, we have it already on hand,
Thank
Your
you very
Honor.
much for that
Thank
prompt
you,
action.
po.
Very short interjection,
Yes,
Mr. Chairman.
before we will proceed, now before I'll recognize for the delayed, long overdue interjection of the Honorable Tibes, the chair first would like to recognize the presence of the Honorable Representative Rodante Marcolita, my idol. Welcome to this committee. The Honorable Representative Raul Delmar is just out. He was here a while ago. Okay. The Honorable Tibis, what is that point of interjection?
Yeah, matanong ko lang kay Senior Superintendent Domingo. Di ba yung nahuli nyo sa pat session, ilan yon? Isang pat session, ilan nahuli? 4 sa isang pat session. 'di ba? Lahat sila charged ng illegal possession of gamit, 'di ba? Ilang gamit na huli nyo? Tig-isa silang gamit? Bale, nagpa-pat session sila, tig-isa silang gamit?
Sir, iba-iba sir. Iba-iba sir.
Kaya tig-isa silang
Yes, sir,
gamit.
yes, sir. Yes.
Paano tinawag na pat session yun kung tig-isa silang gamit?
Sir, kanya-kanya sila sir na... Sir, kasi sir, yung...
Sige.
Nakakalam nung buong istorya kasi sir, yung arresting officer.
Sige lang,
sir,
so sigurado kayo meron silang tig-isang gamit?
Yes, sir.
Usually kasi they share gamit. Parang sa inuman they share baso.
Sir, magkakasama kasi sila sir sa isang grupo sir.
Alam ko, pero tig-iisa silang gamit or isang tutor lang ginamit nila o isang water pipe?
Sir, nagpapalitan sir. Papalitan sila sir.
Kaya nga, so isang gamit lang. Paano pinagmayari ng apat ang isang gamit? Siguraduhin, ang akin lang kasi dito, nakikita ko ang daming report ng police na dinodoktor lang para lang may masabi.
Yes, sir.
Kung isa lang yung gamit, how can 4 people own 1 tutor or own 1 water pipe? Check nyo lang. Anyway, balikan
Yes, sir.
kita mamaya pag oras ko na.
Apo, sir.
Thank you.
Okay. The Honorable Gwin Garcia, you are asking for recognition.
Thank you, Mr. Chair. First of all, may I manifest that I recognize the seriousness and gravity of the subject of this motu proprio inquiry, which is the alleged presence of secret detention cells. And surely a more extensive discussion must be made as regards this grave issue. However, I beg the indulgence of my colleagues in that, while this is the second item in the agenda, third item refers to 2 resolutions that pertain to the Cebu Provincial Detention and Rehabilitation Center. And since some of my colleagues here, like myself, are about to attend at 2 o'clock another very important meeting on the 5th floor of this building, may I beg your indulgence that I request the chair that item 3 be now considered for deliberation and put in abeyance item 2. So move, Mr. Chair.
The chair would like to inform my distinguished colleagues that the committee now is authorized by the Committee on Rules to have our hearing extended up to 4 o'clock. But the chair would relinquish the chair to Vice Chairman Ching Doloso by 2 o'clock because the chair has to defend the amendment of the anti-money laundering law before the Committee on Rules. Now, with that manifestation also of the Honorable Deputy Speaker Gwin Garcia respectfully appealing to the committee that we will suspend first deliberation of item number 2 and that we have to reopen the initial consideration of item number 3, which is his 2 resolutions, so that this 12 to 2 o'clock can be used for that deliberations to allow the other members of this committee and the members of the House who have equally important appointments and hearings by 2 o'clock. So if there is no objection from the members, the chair would terminate would suspend the deliberations of item number 2. But before I will suspend the deliberations, I will first recognize 2 distinguished members. One, the Deputy Speaker, Fred Castro, who would just like to manifest for the compliance of the submission of some documents. And second, we will yield first to the Honorable Romeo Acop, who would interpolate under the, item number 2 because by 2 o'clock he has also a committee to preside, and that is the Committee on Public Order. Before the chair will roll, the Honorable Fred Castro is recognized for some manifestation in relation to the documents submitted by the PNP.
Mr. Chairman, I have with me in my possession several pages of documents purportedly excerpts of the police blotter of Rahabago Police Station. The first page is unnumbered. This is followed by page number 478. And after 478, there is no page number 479, 480, and 481. May I therefore move, Mr. Chairman, that this committee, as well as this representation, be furnished with page number 479, 480, and 481 of the police blotter of Rahabago Police Station, as well as, I presume, it is page number 477. 4 pages, Mr. Chairman.
Okay.
Another, Mr. Chairman.
Go ahead.
I learned a while ago from the representative of the Commission on Human Rights that they have filed the necessary complaint with the Ombudsman for purposes of urging the Ombudsman to conduct an investigation. May I know first, Mr. Chairman, whether in this complaint filed before the Ombudsman, the documents pertinent, all the documents pertinent to this issue are attached to the complaint as annexes.
The Commissioner of the Commission on Human Rights, Commissioner Dompit, may respond to the query of the Honorable Deputy Speaker.
Yes, Your Honor. In our report, we have all the attachments. We have the affidavits as well as the video recording.
The answer is
How
in the
about
posted.
other documents, like for example, your investigation report? They are
there
also
po.
attached.
Yes, they are
Considering
attached.
the manifestation of the representative from the Commission on Human Rights, Mr. Chairman, may I also move that this representation as well as the committee be furnished with a copy of the complaint filed with the Ombudsman, urging the latter to conduct an investigation with complete attachments, more or less 10 days prior to the next hearing of this item, Mr. Chairman.
Okay. The Commission on Human Rights Representative Commissioner Dompit is directed to submit the documents required by the Honorable Deputy Speaker to the committee. It's the committee secretary that will furnish the individual members who desire such.
The same motion, Mr. Chairman, as to the pages of the police blotters of Rahabago Police Station, particularly pages number 477, 479, 80, and 81 of the police blotter, Mr. Chairman, more or less 10 days before the next scheduled hearing.
The Manila Police Director, Chief Superintendent Coronel, is directed to submit the required documents as enumerated by the Honorable Deputy Speaker within 7 days from today. Okay, so ordered.
That's all, Mr. Chairman.
Thank you very much, the Honorable Deputy Speaker. The Chair now will recognize the Honorable Romeo Acop. His turn to interpolate the resource speakers still on agenda item number 2.
Thank you, Mr. Chair. Before I proceed, may I ask if this will be the first or last meeting regarding this issue?
Definitely, Your Honor. This subject matter cannot be disposed today, and there will still be another hearings that will be conducted.
Thank you, Mr. Chair. And because of the manifestation of the Honorable Deputy Speaker Gwen Garcia, I would just like to reserve my questions in the next hearing. I have certain questions prepared already, but I would just like to manifest one thing, Mr. Chair. First, my conflict of interest. I have been a member of the PNP. I retired in 2001 together with Senator Lacson, and Attorney Jigs Coronel, now a chief superintendent, has worked with me. So that is my conflict of interest. Be that as it may, being a former member of the organization, I would just like to make of record that I am not happy with the performance of the Philippine National Police present here in today's hearing. As a matter of fact, we have seen how a station commander changes his answers every now and then. That is not supposed to be the character of a station commander. Why? Because he's expected by our rules that he should know what happens within his jurisdiction. I do not know if the investigating officer took into consideration several laws which might have been violated by the station commander. I do not know. And that would be asked in the next committee hearing as far as this issue is concerned. So, Mr. Chair, thank you for this opportunity. And as you have said, I would have to chair a hearing as far as the Committee on Public Order and Safety is concerned. Marami pong salamat.
Thank you very much, the Honorable Romeo Acop. Now, the Honorable TVS is recognized as the last to interpolate in this particular item number 2 of the agenda today. Still on the motu proprio inquiry in aid of legislation on this alleged secret detention cell. Honorable TVS.
Thank you, Mr. Chairman.
You have the floor.
Yeah, I'll try to keep this as short as possible, but I really have so many questions because this is connected again to what happened yesterday. The relief order. Kanina, nakita ko na order lang ng superior, relieve na kaagad. Correct? Okay. Kahapon kasi, tinanong ko kung paano yung relief order. Sa amin kasi, pag nag-order yung gobernador na i-relieve yung isang hepe ng mayor ng kalaban niyang mayor, nire-relieve kaagad ng PD. Nagtanong ako kahapon sa hearing namin kung ano ba talaga sistema ng relief. By cost daw. By cost ba or sa kagustuhan lang ng superior? Dahil dalawa na naririnig ko na statement ng PNP eh. So hindi ko na alam kung ano yung katotohanan, ano yung hindi. Or both are true.
To whom are you directing your question? To the police director? We have here the police
I
director.
think it should be the highest official present.
The highest official present is Police Director Albayalde. May you please respond to the
Thank you,
query?
Your Honor. Actually, the answer is correct because there's a cause already here. There's a cause for the relief. It's because there is an incident. And there's remember, sir, the administrative relief is not punitive in nature. This is just to pave the way for an impartial investigation. So the cause there's an investigation being conducted by the Commission on Human Rights. So as a commander, we have to decide for the immediate relief of the station commander to pave the way for an impartial investigation so that she will not be able to influence the investigation to be conducted.
Okay. Thank you very much, no? Tinatanong ko, so ilan pala standards ng PNP? Sa amin kasi dati, meron akong nireklamo na yung PD namin, si Colonel Chempo, nag-whitewash sila ng raid sa provincial jail. So nagreklamo ako, bakit hindi siya nirelieve na meron din issue? Ngayon may issue nirelieve. Yun may issue, dinala ko pa sa Congress, hindi nirelieve. So how many standards do we have?
Well, Your Honor, sir, that will be now on the prerogative of the commander because the commander has also his prerogative as a commander. As a regional director, I also have the prerogative to relieve erring policemen or probably policemen who are allegedly involved in any illegal activity, just like what we're doing now.
Kaya nga, so ang nakikita ko dito, Mr. Chairman, prerogative. walang standard. So dito natin makikita na madaling abusuhin ng mga pulis dahil wala ngang standard. Sana lang bago tayo mag-budget hearing, magkaroon na kayo ng standard. Hindi pwede prerogative. Ito, halatang nagpo-proteksyon ng illegal. It will be connected to Ma'am Gwen's investigation later again. Nireklamo ko dito sa Kongreso, kung hindi ako nagalit ng budget hearing, hindi pa i-relieve yung PD si Chempo eh. Halatang halata na meron silang kagagawan doon sa raid na yon na kalokohan dahil pagkatapos ng raid, pinakausap ko pa kay General Bato yung inmate through the cellphone. Ibig ko sabihin, it's very obvious, nakikita ng publiko at ng committee ito, na wala palang standards yung relief ng PNP. Hindi pala cause kung hindi, kakasabi lang ni Director Albayalde na prerogative lang.
May I just clarify, Your Honor? It's a prerogative, and of course, there's a standard. What we say about the policy, we have the policy like we have this command responsibility. We have this command responsibility clause also, wherein if a commander knows that his subordinates are doing something illegal, then he should also be held liable.
Okay, may I continue, Mr. Chairman? Ano lang to dahil this is very important eh. Ang inaano ko lang ngayon, sa amin ngayon, ang lakas ng illegal gambling. Dinala ko na dito hanggang ngayon, hindi pa nare-relieve yung mga tao doon eh. So again, my question is, sana magpadala kayo dito sa committee ito ng standard ng relief at yung di ba? Please put it in writing yung sinabi nyo na prerogative. Because kailangan talaga baguhin yun. Hindi pwede yung puro na lang prerogative.
Mr. Chair,
Yes.
The Honorable Tebes, probably your query can be best answered by the highest official of the PNP, which is the PNP chief. Yesterday, the answer made by Deputy Director General Apolinario was the policy was a policy statement of the PNP. He is being the second in rank, and what is invoked now by the regional director that in every policy there is also a delegation of authority. Where in that delegation of authority there is what we call inherent commander's responsibility. And in that commander's responsibility, there is what's called judgment call on the matter. So that is what the good general mean of a commander's prerogative. Nevertheless, we can bring out your best concern insofar as what happened in your province in the Committee on Public Order.
Okay. One last.
Okay.
Alam mo, dinala ko lang yan dito. I'm not after what happened to my province. Kaya nga tinanong ko ngayon dahil gusto ko makita yung consistency ng mga sagot ng PNP. Dito ko nakita na iba yung sagot kahapon, iba yung sagot ngayon, walang standard. Hindi naman kasi pwede yung prerogative kahit mali. Mali, prerogative pa rin. I don't see the logic behind it. Anyway,
there is an interjection of the Honorable Romeo Acop.
The officers of the PNP present today cannot explain actually the policies completely, simply because they haven't exercised that jurisdiction. First, the prerogative flows from the principle of command responsibility. As I've said, whatever happens or whatever your unit fails to do, you are responsible as the commander. That is the basic principle of command responsibility. And if something is done not properly under your command and you do not do anything, then you are also responsible for that. And that is precisely the reason why a commander relieves his men if he sees to it according to his judgment that it is necessary already for him to relieve that person. Thank you, Mr. Chair.
Okay, the Honorable Tibis, you may proceed.
Okay. Sabi nyo command responsibility. So sino kailangan managot? Sino kailangan mag-resign or ma-relieve sa nangyayari sa amin ngayon? Galing sa inyo. Sagutin nyo ako. Kailangan alam nyo yun.
Mr. Chair.
Yes, the Honorable.
Hindi po nila masasagot dahil ito sa NCR region I think the
Sorry,
appropriate
Your Honor, we
officers
cannot-
who could be able
yes.
to answer that question would be the regional director of the Region 7 would be able to answer this, so that he will be able to explain why he has not relieved that person in spite of the numerous complaints of the Honorable Tevez.
Ang sabi ko
Honorable Tibis,
That's not-
in the next item, I think the regional director of the Region 7 PNP is here.
aabot tayo
You can
doon.
raise that question.
Hindi, ang tinatanong ko lang, command responsibility, di ba? Kung hindi nasagot ng regional commander, sino yung susunod? Ibig ko sabihin, it's very easy to raise command responsibility. Ibig ko sabihin, kung sa akin command responsibility, kung ako yung pinakamataas na opisyal, merong ginawa doon sa baba, di ba? At hindi naayos, responsibilidad ko yun eh. Kaya gusto ko galing sa bunganga nyo, kaninong responsibilidad yung nangyayari ngayon sa buong Pilipinas ng PNP, sabay walang ginagawang relief or matanggal man lang sa serbisyo. I hope you get my point. Ang dami na kasing nangyayari eh. Kahit yung kalokohan na report na isang tutor, 4 yung may-ari, kalokohan yun eh. Where's the command responsibility? I want it to come from you. It's very easy to say command responsibility. Who is responsible now? Give me a main person that you are pointing out to command responsibility. That's what I'm trying to drive at. Anyway, I don't want to take so long. We will that's my last question, Mr. Chairman.
Okay. Thank you very much, the Honorable Tibis. Anyway, you have reserved your right to post through with your other questions in the second round.
But I demand an answer now. Who is responsible now? I want it to come from their mouths.
Okay.
Si Bato ba? Si Presidente ba? Di ba?
We first... okay,
I want it to come from them, Mr. Chairman. Kung sino yung tinuturo nila sa command responsibility. Yung PO1 ba or yung general?
considering that the question raised by the Honorable Tibis calls for a national policy and the highest ranking official here is a regional director, I asked the regional director, police director Albayalde to answer if he may wish, but you are not obligated to answer it if it is beyond your authority to answer such policy statement.
Basically, Your Honor, it's the immediate superior. If the station, like what happened with Police Station 1, then it should be the team leader of the drug enforcement unit and then the station commander. So that's basic with our command responsibility policy, sir. Your Honor.
Okay.
Mr. Chairman, I'm sorry, I'm not satisfied because what if the immediate superior does not do anything?
Okay.
Who is again responsible?
I am giving the Honorable Akop 1 minute to expound the answer. Probably that would more or less give way to a satisfaction on your query. The Honorable Akop.
Thank you, Mr. Chair. In the Philippine National Police, there are layers of command. We have the Chief PNP, which has overall control and supervision over the Philippine National Police in the entire country. Now, he has under him commanders known as regional directors who are responsible for whatever happens or whatever their units fail to do within that region. Now, under the regional director, we have provincial directors in charge of peace and order insofar as the provinces are concerned. Now, the provincial directors have under them their station commanders or chiefs of police of different municipalities and towns under the province. Now, the chief of police is responsible to the police provincial director. The police provincial director is responsible to the regional director, and the regional directors are responsible to the chief of the Philippine National Police. So, it is in the exercise of their command responsibility or their functions na nagagawa ito. That is how the organization of the PNP works. Even in the imposition of administrative penalties to erring PNP personnel, the chief of police has jurisdiction on certain levels. The provincial police director has also authority to discipline his men or impose penalties. So with the regional director. So ganun po yung sistema doon sa Philippine National Police. That is how the command responsibility or the performance of the respective functions in the respective areas of jurisdiction go, Mr. Chair.
Okay, thank you very much, Honorable Akop, for your amicus curiae. Upon request of the Honorable Deputy Speaker and without objection from the members present, the Chair would suspend the deliberations of item number 2 in the agenda, motu proprio inquiry in aid of legislation on the alleged secret detention cell at the Manila Police District Station 1, to be resumed probably before after 2 o'clock. May I just appeal for the indulgence and kind consideration of our resource speakers who are here. No, let us just take advantage of the remaining time granted to us by the Committee on Rules to hold the committee hearing until 4 o'clock. And the Chair now opens the deliberation, the initial consideration of 2 House resolutions introduced by the Honorable Deputy Speaker Gwen Garcia, such as House Resolution number 314. It is a resolution calling for an investigation in aid of legislation on the proliferation of illegal drugs at the Cebu Provincial Detention and Rehabilitation Center, CPDRC, and the other one is House Resolution number 874. It is a resolution calling for an investigation in aid of legislation on the alleged cruel, inhuman, and degrading treatment of prisoners at the Cebu Provincial Detention and Rehabilitation Center during the raid conducted on February 28, 2017. Considering that the issues in these 2 resolutions have commonalities, then the committee will consolidate these 2 resolutions. And to start with the deliberation, may I recognize the Honorable Deputy Speaker Gwendolyn Garcia for her opening or preliminary remarks or sponsorship speech on her 2 resolutions. You are now recognized, the Honorable Deputy Speaker.
Thank you, Mr. Chair. Indeed, these 2 House resolutions have commonalities. The most glaring of which is that both resolutions deal with the Cebu Provincial Detention and Rehabilitation Center, or for short, the CPDRC. It is a provincial jail located in Barangay Kalunasan, City of Cebu, owned, managed, and operated by the provincial government of Cebu. In fact, under the revised Administrative Code of 1917, Section 1731, under Chapter 5, Article 3, Provincial Governor as Keeper of Jail. The Governor of the province shall be charged with the keeping of the provincial jail, and it shall be his duty to administer the same in accordance with law and the regulations prescribed for the government of provincial prisons. The immediate custody and supervision of the jail may be committed to the care of a jailer to be appointed by the provincial governor. The position of jailer shall be regarded as within the unclassified civil service, but may be filled in the manner in which classified positions are filled. And if so filled, the appointee shall be entitled to all the benefits and privileges of classified employees, except that he shall hold office only during the term of office of the appointing governor, and until a successor in the office of jailer is appointed and qualified, unless sooner separated. I go on in the second paragraph, that states, the provincial governor shall, under the direction of the provincial board and at the expense of the province, supply proper food and clothing for the prisoners, though the provincial board may, in its discretion, let the contract for the feeding of the prisoners to some other person. Again, in the Local Government Code, Section 468, Paragraph 4, Number 7, the provincial board is mandated to establish and provide for the maintenance and improvement of jails and detention centers, institute a sound jail management program, and appropriate funds for the subsistence of detainees and convicted prisoners. And so clearly, provincial jails, in contrast to municipal, city, and even the new Bilibid prison, is unique because it does not fall under the management of the Bureau of Jail Management and Penology. It is wholly under the supervision of the province of Cebu, in this case, with the governor of Cebu as keeper of the jail, with a duty to administer the same in accordance with law and the regulations prescribed for the government of provincial prisons. Now, in 2013, and may I now greet the governor of Cebu, who has come all the way, flown all the way from Cebu, in spite of his busy schedule. I know how busy a governor's schedule can be. I was once a governor of Cebu, and two of my colleagues here had also served as provincial board members under my administration. So thank you, Governor Hilario Davide Jr., for your presence. I would also wish to thank Board Member San Shimura, a member of the provincial board, who had also served in my last term, in my third and last term as governor, and continues to be an incumbent member of the provincial board, who heads, as he had headed the Committee on Peace and Order, which, amongst its many responsibilities, also tackles jail matters. In the year 2013, Governor Hilario Davide formally took his oath as the new governor of Cebu. And shortly thereafter, appointed a new CPDRC warden, as well as a consultant for jail matters. As warden, he appointed Vicente Manansala, and as consultant for jail matters, the governor appointed Mark Toral. Now, Mr. Mark Toral, as is shown, this is Mr. Mark Toral, is known by everyone, as he himself had admitted, to have been previously charged with violations of the Dangerous Drugs Act. In fact, he had served time in the Mandaue City Jail for about 8 years, after which, according to him, his case was on appeal, and in this particular interview that he gave to Mr. Ador Vincent S. Mayol of the Cebu Daily News, he stated himself, "I know how it feels to be imprisoned." In 2002, Toral was arrested inside the Mandaue City Sports Complex for allegedly selling less than a gram of shabu to a female friend. The woman had earlier tipped off the NBI. After 8 years, his case in the Court of Appeals, he had earlier been convicted by the Regional Trial Court for life imprisonment and sentenced for life imprisonment. His case, he elevated this to the Court of Appeals, and the Court of Appeals subsequently, according to this interview, reversed the decision of the RTC. Mr. Mark Tural, if you could see, even in this interview, showed off his tattoo. This tattoo, according to him, shows proof of his 7 years behind bars, his BC 45 tattoo for Batang Cebu 45, inked by fellow inmates. Mr. Chair, it is notable that in our Justice Committee hearing on the new Bilibid prison anomalies, specifically on the proliferation of drugs in the new Bilibid prison, one of the inmates that had submitted an affidavit was named ex-police officer Engelberto Acenas Durano, miyembro ng Batang Cebu Brotherhood BC 45. The coincidence is quite striking, Mr. Chair, because by his own admission, this Mr. Engelberto Durano had in fact stated in his affidavit that they were supplying shabu. Sinabi ko agad sa kanya, mayroon akong kaibigang nakalaya na ang pagkakulong ay mayroon siyang malaking negosyo ng pagbibenta ng shabu sa Cebu. He was referring to, tinutukoy ko noon, si Jeffrey Diaz alias Jaguar, dahil dito sinabi sa akin ni Ronnie na siya ay lubos na interesado na makausap. Well, so much for the tattoo of Batang 45. I am told that Batang Cebu 45 is exclusive only for those that come from Cebu. Now, after the appointment of Mr. Tural, there started to come in reports about illegal drug trading happening in Cebu. In fact, in a Freeman article dated July 31st, 2014, where two pushers were nabbed in Liloan, these two pushers claimed or admitted that the drug supply came from CPDRC. Furthermore, because of the so many anomalies that were starting to happen, including the taking out of an inmate by Mr. Toral himself without a court order, because he apparently broke his ankle and brought him to Cebu Doctors Hospital, which again inflamed another controversy, and claims by the Vice Governor herself, Agnes Magpale, in an article that was written by Christine Quintas, staff member of the Freeman, dated August 16, 2016, I quote, Magpale claimed that Toral, consultant on jail matters, allowed married inmates to rent conjugal rooms, earning him as much as 20,000 to 30,000 per month for each room, without the knowledge of government. She alleged that the wife of a drug lord, a certain June Noel, has free access to the jail without submitting to inspections. This all culminated, Mr. Chair, to an August 13 Greyhound operation made up of a composite team of PDEA, the PNP, and perhaps the NBI and other law enforcement agencies, which yielded several grams of shabu, weighing scales or drug paraphernalia, amongst other contraband items or items that were not supposed to have been inside the jail, including cash. At that time, right after the results of that raid, I called for an investigation asking on who ultimately must answer to the proliferation of drugs inside the CPDRC. I understand that the provincial board also called for an investigation. However, after one appearance by the warden, Mr. Manansala, he resigned, and Mr. Toral, perhaps a previous member of Batang Cebu 45, also resigned without ever appearing before the provincial board. 8 months later, Mr. Chair, once again, a Greyhound operation was conducted by the PDEA. And once again, the results of this raid, PDEA, the composite team composed of the PNP, as well as, PDEA, the PNP, and other law enforcement agencies, once again yielded shabu, drug paraphernalia, and other contraband items. But the fact that still there was the proliferation of shabu, that was overshadowed by the photos that were splashed across headlines, front pages in local dailies, as well as in the social media of CPDRC inmates stripped naked and made to squat in the quadrangle of the jail facility, huddled together in the presence of the female inmates. Immediately, Amnesty International, Human Rights Watch, and other so-oriented groups raised a howling protest against, and may I quote Amnesty International, the cruel, inhuman, abhorrent, degrading treatment of prisoners, violative of the rights of the inmates. Vice President Leni Robredo, who was also in Cebu on March 4th, was also quick to condemn the raid, citing possible violations of Republic Act 9745, the Anti-Torture Act, and described the treatment of the inmates as troubling, cruel, and inhuman, as well as nakakabigla and nakakabahala. In fact, Amnesty International was quick to compare the operation to the infamous Auschwitz concentration camps maintained by Nazi Germany during World War II. And so, Mr. Chair, the issues that we need to deliberate on are the following. First of all, President Rodrigo Duterte has made it of utmost priority in his administration that the war on illegal drugs and criminality be seriously addressed. Sadly, in a speech that President Duterte delivered just recently. He called out Cebu as being number 1 in drugs. According to him, mga 60 to 70% ang infiltration daw ng drugs. This was disputed by, of course, I'm glad that he's here, Regional Director Talino. I'm trying to look for the news item. And Mr. Yogi Ruiz, the PIDEA Regional Director, who even went so far as to say that the President probably had old data. But the chairman of the Committee on Public Order and Safety is here. And I do recall that I had questioned in one of our committee hearings General Bato de la Rosa, and I had asked where, in fact, the President gets his data. And he admitted that he has more accurate data than the PNP himself, the PNP organization itself. And so the issue on the proliferation of illegal drugs is of utmost priority here, especially since the Cebu Provincial Detention and Rehabilitation Center is like a microcosm of the province itself. The inmates that are confined at the CPDRC come mostly from the 44 towns and 7 cities of the entire province. It is sad to note that several news reports have pointed out that those drug peddlers apprehended would point to the CPDRC as the source of shabu. In fact, according to Magpale, Vice Governor Magpale, again in this same article, from the Freeman, written by Christine Quintas, Magpale said Tuburan Mayor Aljun Diamante alleged that drug supply in his town, Tuburan is a town in my district, the 3rd district of Cebu. Mayor Aljun Diamante alleged that drug supply in his town came from CPDRC. Board member Edsel Galios also said drug suspects they apprehended also reported they sourced from CPDRC. That's the first issue. The proliferation and the obvious trading of drugs inside the CPDRC. The second issue, that as a result of the second raid, which again yielded packets of shabu and drug paraphernalia, the howl and cry of many human rights-oriented groups, including the Vice President, against the cruel and inhumane treatment of prisoners who were made to strip naked and squat on the quadrangle, photos of whom were splashed across social media as well as mainstream media. Third issue, ultimately, who should answer for this? Who should be the accountable government officials or employees that must answer for these anomalies, which even the provincial board, including the vice governor, have glaringly pointed out in their own provincial board session? Now, since this is in aid of legislation, Mr. Chair, the fourth issue here is perhaps something which, in this same article, I may lift from a statement that the governor of Cebu allegedly said. And I quote, "The Capitol is considering letting others manage the CPDRC, considering the issues hounding the jail." Davida said he has been thinking about the suggestion to let the BJMP manage the provincial jail. Cebu, he said, is the only province in the country where the government runs the jail. Well, of course, this last statement is not quite accurate because, as I had pointed out, the administrative code mandates all provinces and all governors to run their jails. They may turn over to the BGMP. I had hoped that our good congressman from Bohol, Congressman Relampagos, would be here because he may have wished to confirm this. What I believe was Bohol had turned over their provincial jail to the BGMP. But last I checked, Negros Oriental, Cavite, Pangasinan, and so many, well, the provinces, it cannot only be Cebu that the government is running its provincial jail. With all of these issues submitted, Mr. Chair, I thank you for this initial deliberation. We have requested for the presence, and as I had earlier indicated, the governor himself is here, board member San Shimura is here, and I also would wish to acknowledge the presence of several mayors from the province of Cebu. Although, of course, we had not extended an invitation, but we appreciate their presence, knowing as well that they have numerous, voluminous documents to sign back home, as well as many other pressing issues that need to address in their own constituencies. Thank you, Mr. Chair.
Okay, thank you very much, the Honorable Deputy Speaker. And in relation to these two resolutions, the committee has invited different resource speakers in order to address the issues raised. We have heard today the Honorable Hilario Davide III, the Governor of Cebu. Before I will recognize him to give his position on the matter. We have also three regional directors here. We have the regional director of the ILG, Director Rene Borgios, who was once my mentor before. We have the regional director of the Philippine National Police, who was the PIMOS sub-officer when we were conducting the Mama Sapano investigation. The good Chief Superintendent Noli Talino of the PNP Regional Office 7. We have here also the Regional Director of the PDEA, Director Yogi Pilemon Roes. And I was wrong. I'll stand corrected. It's not only three regional directors. We have also the regional director of the Commission on Human Rights, the regional director Arvin Ordon. No? And with the CHR regional director is the special investigator Leo Villareno. And we have also here the provincial director of Cebu Province, Senior Superintendent Eric Anobli. And we have also here the spokesman of the PDEA in the person of Mr. Derek Carion, who was also mentioned in the resolution. And as mentioned earlier by Deputy Speaker Garcia, Board Member San Sinora is also around. So that before we will proceed, it was brought to my attention earlier after I had rolled for the suspension of the proceedings of agenda number 2, that there are records which our resource speakers from the Philippine National Police, which they would like to present to this committee. And in view of, for lack of material time, and considering that these officers have also other things to do, which are also their priority responsibility within their area of jurisdiction, unless there are objections from the members present, the chair would therefore decide not to resume the proceedings of item number 2, but will set another hearing for this purpose to allow also the resource speakers to bring the documents required, and the other members of the committee also who have other meetings to attend. So, as I said, unless there is any objection from the members present, the chair would dispense our resource speakers from the Philippine National Police, headed by Police Director Albayalde. Thank you very much for your presence together with your subordinates, and the officers of the Internal Affairs Service and the Commission on Human Rights who are handling these cases of this alleged secret detention cell. Sir, you are excused, and we will advise you accordingly on the next hearing. Thank you very much for your presence today. Now, the chair would now will recognize the Honorable Governor of Cebu, the Honorable Hilario Davide III, for your position on the matters. I understand you are furnished copies of the two resolutions,
Yes,
and you
Mr.
have
Chair.
heard the opening statement of our Honorable Deputy Speaker, who is the principal author of both resolutions. You have the floor, sir.
Thank you, Mr. Chairman. Mr. Chairman, before proceeding to before answering the statements of Congresswoman Garcia, I'd like to thank the subcommittee on correctional reforms for inviting me to this inquiry in aid of legislation on and for giving me this opportunity to present the position of the provincial government as regards the resolutions filed by Congresswoman Garcia. And I'd like to thank especially Congresswoman Garcia for her twin resolutions. Indeed, this is a very opportune time for the provincial government, on whose behalf I will be speaking, to present also the programs, the measures that we have taken to ensure that the CPDRC is ably managed, Mr. Chair. I'd like also to thank the presence of Congressman Del Mar of Cebu City, Congressman Caminero, Congressman Calderon, and Congressman Gulias, all from Cebu, and some mayors from the 2nd and 7th districts of the province of Cebu. I thank them for their presence here. They are here, Mr. Chairman, to observe this morning's proceedings and maybe pick up some lessons as regards the management of municipal jails, as they themselves have their own problems. Mr. Chair, with your indulgence, let me begin by stating for the record that Congresswoman Garcia is correct. She cited the administrative code, which is an American vintage, 1917, but there had been already amendments. As a matter of fact, there is the revised administrative code. But I agree that the provincial governor is the keeper of the jail. That has not been amended as yet. At the CPDRC, we have been actually instituting reforms there, aware that there are problems, myriad problems that need addressing, which is why after the resignation of the consultant Marco Toral, which was mentioned in Congresswoman Garcia's opening statement, I immediately created a task force to oversee the management of the CPDRC. and to institute the necessary measures to ensure that no contraband would enter the facility. Number two, Mr. Chair, I appointed an officer in charge, a warden, to oversee as well, to manage the facility. While I appointed myself warden at that time, I sought the assistance of the head of the Civil Security Unit, Mr. Legaspi, has been also invited to this inquiry, to look after the day-to-day operations, day-to-day management of the provincial jail. Mr. Chair, Congresswoman Garcia mentioned that there were incidents of confiscations or attempts or even confiscations of illegal drugs of the CPDRC. That is correct. In fact, it is unfortunate, although we continue to institute and adopt measures to really ensure that to flush out the illegal drugs at the jail facility. The Greyhound operations conducted last February and much earlier, last August in 2016, was a result of the numerous tips that I personally had received, and also from reports from other sources of the drugs being smuggled into the facility, which is why I requested the PIDEA to conduct a Greyhound operation. And because of that, we also instituted other measures to really address this the problem on drugs. Quite frankly, Mr. Chair, honorable members of the subcommittee, the evil that is drugs simply refuses to die. No less than President Duterte said on several occasions that the war on drugs is not a walk in the park. And we are experiencing the same problem at the Cebu Provincial Detention Center. And this is our way really of supporting the war on drugs declared by the President. We have consistently, we have, besides the Greyhound operations that we requested PIDEA to conduct, we also have our internal raids conducted by the provincial guards at the jail facility. Mr. Chair, the problem of drugs existed not only during this administration, the current administration of the province of Cebu. It has been there since for many years. It had existed for many years, Mr. Chair. And I'm sure people here, the distinguished gentlemen, ladies and gentlemen here, are aware that this is not unique to the province of Cebu or to the CPDRC. The problem is commonplace. Every jail, municipal, city, or provincial jail has its own problems on drugs. This problem is persistent, and we are trying everything really to address this, which is why I am thankful to the provincial board that finally the provincial board passed on third and final reading last week an ordinance adopting the Manual of Operations and Administration of the Cebu Provincial Detention Center of the province of Cebu. And the principal author of that ordinance is right here beside me, Board Member San Shimura. For the first time, we have our own manual because the provincial government never had any manual or even a set of procedures as regards the management and operations of the Cebu Provincial Detention Center. Now, Mr. Chair, Honorable Garcia also brought to the fore my statement of quoting my statement in the local press that I favor the transfer of supervision and management of the provincial jail to the BJMP. That's correct, Mr. Chair. As a matter of fact, I am aware that there are two pending bills here before the House of Representatives, authored by Congressman Bagilat and Congressman Matugas, which seek to transfer the supervision and control and management of the provincial jail to the BJMP. I support that legislation, Mr. Chair, and I hope really for its passage. As regards the apprehension of Congressman Garcia, it should be, of course, one of the provisions that should be placed there in the proposed bill is that the provincial government should retain ownership of the facility. Only the supervision and management should be transferred to the BJMP. On, as regards Mr. Toral, it is true that I got him as consultant on jail matters, similar to what Congressman Garcia did when she was governor, when she appointed a brother to as consultant of the CPDRC. It's true that Mr. Toral was in prison for 7 years, but was eventually acquitted of the crime of violation of the dangerous drugs law by the Court of Appeals. I got him as consultant. He is a friend. I had trust in him. I had faith in him, and I knew that he was going to do. He was going to introduce reforms in the CPDRC. It was just unfortunate that there were so many innuendos and rumors of his alleged complicity at the CPDRC, which forced me to ask for his resignation. But he had indeed introduced so many improvements at the Cebu Provincial Jail. He continues to be a friend, and I just hope that I just hope that the institutions, the reforms that he had introduced, the good ones actually, would be continued at the CPDRC, Mr. Chair. I guess that's all, Mr. Chair, unless Congressman Garcia and the other members of the subcommittee has questions for me. I'd be happy to respond, Mr. Chair. Thank you, Mr. Chair.
Thank you very much, the Honorable Governor. Before the Chair will entertain any interpellations from the members of the committee, we'll first hear the opening statement of the other regional directors who have, in one way or another, has relationship to the issues which are being raised in the two resolutions. This time, I would like to hear the regional director of the PNP, Chief Superintendent Noli Talino. Can you please give your brief position on the matter in relation to the raid conducted and this proliferations of illegal drugs inside the Cebu Provincial Drug Treatment Center, Detention and Treatment Center?
Yes, Your Honor, Mr. Chair, I am the present Regional Director of Police Regional Office 7. And I agree that when I assumed as the Regional Director of Police Regional Office 7 on July 1, 2016, the use of illegal drugs or the affectation of illegal drugs in Central Visayas, I can speak about the entire Central Visayas, is high, considering that based on our validation together with PDEA, the PNP, there is a high barangay drug affectation in the entire Central Visayas. But but because of our double barrel campaign against illegal drugs, we slowly addressing this problem, and from July 1 up to May 15, we have this accomplishment on illegal drugs. We have more than 7,000 arrests of drug pushers and drug users for the entire Central Visayas that covers Cebu Province, Bohol, Siquijor, and the three highly urbanized cities of Cebu City, Lapu-Lapu City and Mandawi City. And aside from the more than 7,000 arrests, we have more than 107,000 surrenderers from July 1 to date. And we have also some accomplishments on legitimate police operations of, I think, 160 plus. So that is our humble accomplishment of Police Regional Office 7 when it comes to our project Double Barrel, including the second phase and project Double Barrel Reloaded. So that is now what we are implementing now.
Excuse me.
Yes, Your Honor. Yes, sir.
Can you please focus your position on the proliferations of illegal drugs in the Cebu Provincial Detention Center? No, we understand your accomplishments, yeah. But because of what has been at issue here is the proliferation of drugs inside the provincial jail, whether or not you agree that as Police Director of Region 7, where Cebu is under your jurisdiction, whether there really exists or it is true that there is a proliferation of illegal drugs inside the provincial, the Cebu Provincial Detention Center. And in relation also to that trade on February 18, 2017, where there is an element of the Philippine National Police who were part of that trade, there is an allegations that there was that cruel, inhuman treatment of the inmates. So can you please focus your statement on that particular issues?
Yes, Mr. Chair, that will be part of my statement. And to concentrate on the issue of the CPDRC, last year, during the first or initial inspection that we conducted at the CPDRC, it was actually a simultaneous operation. Initially, the former Provincial Director, Police Senior Superintendent Jose Macanas, informed me that the Governor Davide, requested him to conduct surprise inspection together with the some provincial government staff. And accordingly, the governor will call me on this and inform me about their plan to conduct inspection. So few days before the actual operation, Governor Davide called me up and said that one of his staff, I think Mr. Bobby Ligaspi, will proceed to my office and coordinate about this operation. And true to it, the provincial director and Mr. Ligaspi went to my office and then we discussed about this plan operation at CPDRC because of some information that illegal drug activities are being conducted inside the provincial jail.
May I interject, Mr. Chair? I
Yes.
believe Regional Director Talino is now referring to the second raid. Would you
No,
kindly,
ma'am,
because
this is the
Legazpi is now the OIC, it has been quite a succession of OICs or wardens that have been assigned to the CPDRC. Are you referring to the first raid?
Yes, ma'am. The first raid, ma'am. Because
And
The first raid is August 2016.
yes, sir.
And
Yes,
the second raid is
Mr.
February
Chair.
18. Okay, so your manifestation refers to the first raid sometimes on August 2016.
On August 13,
August 2013.
2016.
August 13, 2016. I'm sorry.
Yes, Mr. Chair. Because he was the one sent by the governor, so siya yung in-entertain namin doon sa office.
What was his position then?
I do not know, ma'am, Your Honor, because I was just informed that Mr. Gaspi will be visiting me in my office.
Wasn't there a warden formally appointed at the time, Vicente Manansala?
Can you answer that? We asked first the director.
It was Mr. Legaspi who went to my office, Mr. Chair.
And you are not fully aware on what is his appointment, what is his position? he is just a representative of the office of the governor, and that is what you know?
Yes, Mr. Chair.
Okay. So that others can now interpolate. Can you please direct now? Do you agree that there is that proliferations of illegal drugs in the provincial Cebu Provincial Detention and Treatment Center? Just answer it yes or no. During your stint as regional director, can you agree that there is such proliferation? And then answer also the second question. Do you agree that there was that inhuman, cruel treatment of the inmates during the raid on February 18, 2017, so that the other members could now start interpolating?
Yes, Mr. Chair, on your first question, the provincial director was the one who briefed me about the illegal drugs activities at the provincial jail, and he just said that there were some illegal activities ongoing at the provincial jail, because we were concentrating on the illegal drug activities outside
Okay.
the provincial jail. So
No.
that is the only.
What about the raid? What can you say about the raid? Do you agree that the treatment of the inmates by the raiding team, which includes the Philippine National Police, was inhuman, cruel?
Personally, sir, I don't think it was inhuman. It was not the PNP who lead the operation on the second inspection
Yes,
that
but
was
there are
conducted.
elements of the PNP.
Yes, there were some provincial police office involved. I think they were just support of the operation conducted by the PDEA.
And what was the report of the Philippine National Police elements who were part of the team insofar as the treatment of inmates are concerned?
Based on the report of the provincial director, police senior superintendent Noble, there was no inhuman treatment during that operation.
Okay.
Mr.
Thank you.
Chairman.
Before we will hear first the regional director of the PDEA in order to have more or less an inclusive information as to the issue. Director Ruiz of the PDEA.
Yes, sir.
Do you agree the statement of the regional director that there is that of the police, that there is that proliferations of illegal drugs inside the Cebu Provincial Detention Center as reported by his provincial director, and that the allegations of cruelty, inhuman treatment of the inmates during the February 18 raid, which was spearheaded by the PDEA, is true or not? Go ahead,
Yes.
Director.
Yes, sir. Mr. Chair, to the members of this subcommittee, good afternoon. I am Yogi Ruiz, the Regional Director of PDEA 7. I assumed as Regional Director of PDEA last July 2016. And one of the orders I received immediately from the governor after one of our meetings was to conduct search and seizure operations like Greyhound operations in CPDRC, because I confided to him that there were numerous information that there were prisoners inside the jail that were still continuing their illegal activities, and he immediately told me to conduct operations that will lead to the arrest of these personalities. So, yes, sir. And I would just like to point out, sir, that from 2009 to 2015, there were only 4 Greyhound operations by PDEA and other law enforcement agencies. But when we took over Jaltalinio and together with PDEA, by 2016 alone, we were able to conduct 12 Greyhound operations, and in 2017, we were able to conduct 19 Greyhound operations.
Drugs, because you had conducted that Greyhound operations. Now, what about the allegations of that February 18, 2017 raid of inhumanity and cruelty? What's your statement on that matter?
Yes, sir. I think there is no proliferation of illegal drugs, sir, but there is more increased vigilance in the part of operations being conducted inside the jail, sir.
Yeah, but when you conducted the Greyhound operations, it yielded illegal drugs. Am I right?
There were operations that no illegal drugs were found, sir.
Okay. So what about your February 18, 2017 raid? What can you say about that? As to the allegations of inhumanity, cruelty.
First of all, sir, let me give a brief background. I received a letter from the governor asking PDEA to conduct a Greyhound operation, surprise inspection on CPDRC. And I was designated as the ground commander that time. Based on our experience when we conducted the raid on simultaneous raid on CPDRC and BBRC last August of 2016. In BBRC alone, we were able to confiscate around 4,600,000 pesos in cash and numerous drug paraphernalia, bladed weapons, and drugs. And I would like to point out also, during that time, sir, all prisoners were also made to strip, and it is a standard operating procedure of PDEA and BGMP manual of operations during any operation that strip search is allowed, and for the safety also of the raiding team.
Okay.
There was no inhuman, cruel, and degrading treatment of the prisoners, sir.
Okay. Thank you very much. May we hear from the regional director of the DILG? What is your position or your statement on these two resolutions which are being introduced by the Honorable Deputy Speaker?
Thank you, Mr. Chair. Good afternoon, Your Honors. Your Honors, I am with the local government sector of the DILG, and I'm not very familiar with management of jails because it is under the BGMP. But for purposes of this incident on February 28, I was directed by then Secretary Sueno on March 7 to head a fact-finding team composed of myself as chairman and the BGMP regional director, the NAPOLCOM regional director, and the provincial director of the DILG to submit a report on whether or not the strip search on February 28 was justified and necessary. So after that, we conducted the fact-finding and submitted a report to Secretary Sueno, stating, among others, that for security reasons, there exists a threat or risk to the raiders, to the security forces, and the prisoners. The committee believes that the strip search was justified and necessary under the circumstances. Thank you, Your Honor.
Okay, thank you very much. Gob, you were raising your hands. You wish to be recognized. Okay,
Because,
for 1
yes.
minute, quick reactions on that statement.
Just a clarification, Mr. Chairman, because Governor Garcia mentioned that Mr. Legazpi was the warden then of...
Just for clarification,
yes.
you are the GOP, I am Congressman. You're the GOP.
Sige, salamat ko nga. Legazpi was after August. Toral resigned in around July in 2016. Shortly thereafter, I created a task force and issued a memorandum designating Mr. Legazpi as my assistant. Since I appointed myself warden of the CPDRC, in the meantime, that we were still looking for a warden to manage the jail.
Okay, thank you very much.
Thank you, Mr. Chairman.
Yeah, before we will proceed with the interpellations, may I request the Honorable Ching Biliso to take over the chair. The Committee on Rules is very strict. If you are late, then you will not be allowed to enter and your bill will not be considered in the deliberation.
Mr. Chair, if I may. Mr. Chair.
Go ahead, Your
Thank
Honor.
you, Mr. Chair. In consonance with the manifestation of Governor Davide that Toral had resigned sometime in July, reference to this article, which I have been picking certain issues that I had talked about earlier. This article also stated Toral already resigned as consultant on jail matters last August 8th. So the resignation of Toral was
I stand corrected
the 8th
then.
of
Thank you.
August.
Thank you very much,
you.
Congresswoman Garcia. Thank you.
Okay. The chair now recognizes Representative Teves.
Thank you, Mr. Chairman. Earlier, I heard somebody, I think from the PIDEA, that there is no proliferation of drugs in the jail of Cebu. Am I correct? Did I hear you right?
The statement of the chairman of the subcommittee, Your Honor, was related to the increase in the number of search and seizures in the jail related to the proliferation of drugs in the jail. I would say, sir, that the increase in the number of searches in the jail is not related to the proliferation of illegal drugs, sir, but more on the vigilance and the request from the provincial government for us to conduct search operations inside the jail, sir.
Okay. Ganito na lang para mas madali. Are there drugs present, sold, and used inside the jail of Cebu as of today?
As of today, sir, yes, sir.
Yes, sir. Oh, anong ginagawa? Bakit meron pa rin?
I think that's a problem we have not only in Cebu City, not only in Region 7, sir, but that's a problem we have in almost all of the jails we have,
I'm
sir.
not asking you kung saan yung problema. Ang tinatanong ko, in your AOR, bakit meron pa din? Because if the PIDEA is useless, then during the budget hearing, tatanggal ko na lang yung budget nyo. Bakit may drug? You know, the jail is a controlled environment. I could not understand why drugs still proliferate in a controlled environment. Kung sa labas may rason pa eh. Inside a controlled environment, there should be no drugs present.
Yes, Your Honor.
Is it a lapse of the PIDEA or is it a lapse of the provincial government?
We are not the administrator of the jail, sir.
So are you telling me it's a lapse of the administration of the jail? Are you telling me, is it a lapse of the administration of the jail? Yes or no?
Yes, sir.
Okay. You being in the PIDEA, knowing that there are lapses in the administration of the jail and there being drugs proliferated, you should take action. Because it's not enough that PIDEA says that is not your jurisdiction, because all drug-related cases, it should be under the jurisdiction of the PIDEA. Am I right?
Yes, sir.
Oh, anong ginagawa nyo?
What we have done right now, sir, is we have deployed 2 K9 teams in CPDRC, sir, and 1 K9 team in BBRC, and that is on 24-hour rotation, sir.
Pero may droga pa rin. Ganito, wag na tayo magbulaan dito. Ha? Sinong involved sa droga doon? PIDEA, police, o civilian? Wag na tayo magbulahan. Merong involved sa droga doon, di ba?
Yes, sir. It is
Wala
the
namang
inmates, sir.
magpapatakbong maliit na tao kung walang malaki ug sa binisaya pagkapaluyo, di ba? Oh. Sinong, according to your intel, who's the protector of the drug trade in the jail?
We do not have information regarding protectors, sir, but we have information that inmates are still continuing with their illegal business.
For the record, Mr. Chairman, it's just telling us, is the PIDEA RD?
Yes, sir.
Is telling us that they have very poor intel. Magkano budget nyo sa intelligence?
I do not have information to that effect, sir.
Dapat, paano ka ba naging regional director kung hindi mo alam yung budget nyo sa region nyo, hindi nyo alam? Wala kayong budget for intelligence? Zero? Hindi, kung wala, palagyan ko. Dahil kaya pala wala kayong intel dahil wala kayong budget. Pero kung meron kayong budget, wala kayong intel, tanggalin natin yung budget nyo.
We do not have intelligence fund in the region, sir.
No intel fund.
Yes, sir.
So how do you get intelligence?
Through operations, sir, after operations, interrogations, and through
Don't
contact
you work
meetings
with the
with
PNP?
informants, sir.
In your mandate, don't you work with the PNP for intel?
Yes, sir, we work with them, sir.
O, yun na nga. So may budget pa rin through the PNP, correct?
We do not...
No. Ibig ko sabihin, you work with the PNP. So
Yes,
you
sir.
gather intel from the PNP through their using their intelligence budget. Am I right?
We have our own operatives gathering information on the field, sir.
Do you work with the PNP or not?
We work with them in terms of conducting operations, sir.
Ah, okay. Yung intel sa inyo lang.
Yes, sir.
So wala kayong budget sa intel.
No, sir.
Okay. Then mag-request kayo ng budget sa intel. Dahil nakikita ko, ang dali sabihin ng PIDEA na wala silang alam dahil wala kayong intel budget. Sige, kung totoo yun, tulungan ko kayo. Ha? Okay. Next. Knowing that there are drugs in the provincial jail, who's responsible now?
It is more on the prison guards and then the administration, sir, inside the jail, sir.
Okay. Whose responsibility is it to file cases against drug offenders?
It depends on the arresting person, sir.
So if nobody is arrested, whose responsibility is it? Isn't it the PIDEA's responsibility to make the arrest?
Yes, we conduct an arrest, sir, especially in, there is a peculiar situation, sir, especially if it is inside the jail. It is not that easy to conduct a greyhound operation, sir. It involves, just like the 2 greyhound operations we conducted, wherein we were able to successfully confiscate numerous cell phones and numerous bladed weapons. It took more or less around 2 weeks of planning, sir, to have that operation into fruition.
Dahil kailangan nyo magpaalam sa jail management at sa gobernador, correct?
And that time, sir, it was the governor who requested us to conduct the operation, sir.
Yeah, but still, whether it's the governor requesting, but protocol says, in jails managed by the provincial government, kailangan nyo magpaalam, correct? Hindi.
Yes,
Pwede
sir.
ba kayong mag-grade doon? Parang nag-grade kayo ng bahay na may search warrant na hindi kayo nagpapaalam sa governor at sa jail warden. Pwede, hindi?
Pwede, sir.
Bakit hindi nyo ginagawa? Akala ko ba mahirap? Ba't hindi nyo ginagawa?
It's a matter of courtesy also, sir. It's
See,
quite difficult
that's
to...
what's wrong. You know why I'm telling you all this? Because in our province, it's the same. It's the governor and the provincial jail management doing the drug trade. One time, nagparid ako doon, nagpaalam pa sila, walang nahuli, 0. Pagkatapos, pinakausap ko pa kay Bato, yung inmate using the cell phone right after the raid. Bato was here in Congress. Ngayon, you being the PIDEA, dapat kayo yung nanghuhuli doon. So ganun pala, useless pala yung PIDEA. Useless ba yung PIDEA? Hindi. You answer me because if it's useless during the budget hearing, patanggal ko na yung budget nyo. Tanggalin na natin yung PIDEA dahil hindi pala kayo nakakauli sa provincial jail.
I think it is not useless, sir, because we were able to accomplish...
No. In the provincial jail lang. So when will we cleanse the Cebu provincial jail of drugs? Can you give me a timeline?
It's not that easy to give a timeline, sir, just to satisfy the question of the Honorable Congressman, sir. I will do it to the best of my ability, sir, without...
Hindi pwede yun, boss. Ganito na lang. Sa ganung statement, sorry ha, sa budget hearing, mahihirapan kayo sa akin.
Yes, sir.
Ako, Vice Chairman ng Drugs Committee. Kung hindi nyo mahuli sa loob ng jail, mas lalong hindi kayo makakahuli sa labas. And I like that to be on record now na nagsabi yung PD ng PIDEA na wala silang klaro kung kaya nila tigilin yung drug sa Cebu jail, which is a controlled environment. I'm not really only concerned about Cebu, I'm concerned about all the jails in the country because I used to be a drug addict and I know how bad it is. So, sorry boss, mali yung sagot mo. Dapat alam nyo at my timeline. You know why? Because if you gave me a timeline, I was gonna ask you that if we conduct a drug test there at may nahuli pa rin, are you willing to resign and forgo of all your benefits? Anyway, I don't want to take so long, Mr. Chairman. Meron pa akong meeting sa baba. And I'm really disappointed with the PIDEA's answer. And one last, ilang PIDEA ang nagpapat-involve sa operation ng droga sa Region 7?
What do you mean, sir?
Dati kasi meron akong alam provincial director pa. Siya yung salba ng 1 kilo na droga doon sa amin. Bale, kasamahan niya yung nagbebenta. Tinatanong ko sa iyo ngayon, meron bang isang operative ng PIDEA sa buong Region 7 na kasabwat na nagpapatakbo ng droga?
No, sir. No,
Zero?
None involved, sir. Zero, sir.
So kung merong isang mahuli, are you willing to resign and forgo of all your benefits and retirement benefits?
Yes, sir.
Okay, good. Thank you. That's all, Mr. Chairman.
Next is the Honorable Delmar.
Thank you, Presiding Chairman. I welcome my fellow Cebuanos here, but we could have met here in Manila under more auspicious events. But when I heard that you were coming here, as per the resolutions filed by the Honorable Gwen Garcia, I made time to come here and join this resolution because even if I'm from the highly urbanized city of Cebu, which is independent of the province, what happens in the province is a problem to the city and vice versa. So the drug problems is city and province combined. Now let me first, before anything else, because of the line of questioning and comments of our colleague Congressman Tevez, may I just make of record my personal assessment based on common perceptions on my constituents in my district, at least, primarily. They're doing all right, Mr. Chairman. The police, the armed forces, and PIDEA, they're doing okay. In fact, what is obvious is that they're doing their best, as said by PIDEA 7 Director Ruiz. But then the best will not do. You must do your utmost best just the same. But we do recognize your good work, and we exhort you to keep up the good work. So, that being said, let me say, Congressman Tevez was saying in the jail in Negros, in his district, I guess, when a raid was conducted, nothing was nobody was charged, no paraphernalias, no drugs were discovered, so there was no results. How about, let me ask about that second raid that the governor ordered. Is that correct? The governor ordered the raid, and it was headed by a composite team of PIDEA, PNP, and even AFP, right? But
Yes, sir.
since you were the head, what happened? What's the result of that raid?
Yes, sir. As a result of that raid on February 28, 2017, sir, we were able to confiscate 19 pieces of transparent plastic packs, sir, totaling more or less 10 grams worth 30,000 pesos. 1 plastic containing marijuana, sir. 1 bank passbook, 3 bank transaction slips, 1 money remittance receipt, 75 cellular phones, sir. 3 video players, 1 iPad, 1 laptop. All the cellular phones and then the laptop and the iPad had undergone forensic examination, sir. Various drug paraphernalia and several bladed weapons, sir.
Okay, that's good to hear. Now, what happens? Are the owners of these illegal drug inmates identified? And if they are identified, what do you do? You cannot put them to jail. They're already in jail. Is there any further charge that you can make against these inmates who's found to be responsible for these illegal drugs confiscated in their rooms or whatever?
Yes, sir. Additional charges were filed against them, sir, and the bank transaction receipts that we confiscated together with the bank passbook has already been submitted to the Anti-Money Laundering Council, sir, for investigation and for eventual forfeiture, sir.
Okay, let's go to the second raid. This is talking about the second raid, right?
Yes, sir.
The Operation Greyhound.
Yes, sir.
Which the governor ordered.
Yes, sir.
And which yielded this contraband and illegal drugs. This is the one which has been pictured in the papers, not even locally, international, that it was cruel, inhuman, degrading because of this. The raiders made the inmates strip all of them and squatted together in the quadrangle. And although the women inmates were not stripped, they were there, but at a reasonable distance from the inmates, male inmates who were stripped. So what is this? Is this an SOP, or were you ordered by the governor to do this?
No, sir. I was not ordered by the governor to let them strip, sir. It was my decision as the ground commander that time, because we had information that there were numerous prisoners that they have their own gangs inside the jail, and they were possessing numerous bladed weapons. And considering that there were only 270 of us raiding team compared to 2,759 inmates, sir, I had to take into consideration also, sir, the safety of both the raiding team and also of the prisoners. Because if even one instance would have happened wherein one drug-crazed inmate would have held hostage one of my personnel or one of the raiding team, it would have led into a much bigger chaos or a much bigger situation wherein it would have been much different outcomes or compared to what happened that night, wherein not a single inmate was hurt, degraded, or even shouted upon.
Okay, so you stated that this is not the first time you conducted a raid at the Cebu Provincial Detention Center.
Yes, sir.
Is that correct?
Yes, sir.
In the past raids, did you also ask the inmates to strip?
Yes, sir.
You did? How many raids did you make wherein you applied the same procedure in commanding the inmates to strip and squatted together in the quadrangle?
In 2016, sir, we conducted 12 Greyhound operations with the same procedure. All operations led to successful operations, not a single inmate or reading operative was hurt. And in 2017, 19 search and seizure operations, also with the same procedure, not a single operative or inmate was hurt during all raids that were conducted, sir.
Okay, but I guess there were less complaints about that. Not like this last one, where the complaints even reach international levels. No? So I guess, isn't it possible to have a room wherein they can go in and go out, and when they're inside that room, that's the time that they are privately stripped, instead of stripping all of them together and making them squat for a length of time in the open corridor where everyone can see them. Even the female inmates can see them.
The procedure we have, sir, is it is quick and what we call it, sir, surprise inspection, wherein the inmates will not be able to dispose or hide any contraband in their possession. So what we do is the reading team are being segregated into different cells, and they have their own cells to secure. All inmates are being, before going outside, they are made to leave their undergarments inside. Actually, we also did it in other searches, other jails.
Mr. Chair, the regional director is not responsive to the very specific question of Congressman Del Mar. Isn't it possible, if I may recall, that instead of stripping all of them and making them squat and huddle all together, all 2,000 or perhaps 3,000 of them in the quadrangle, that you would set aside a room so that this does not have to be done in the presence of the female inmates?
Before that, the chair would like to invite the attention of the PDEA director to Section 14, Republic Act 9745, which penalizes cruel, inhuman, degrading treatment. When you require a detention prisoner to strip before the eyes of other people, is that an inhuman treatment by your standard?
No, sir.
So,
No, sir.
if it is not, would you still continue with that?
Your Honor, let me cite, based on the PDEA and BGMP Manual of Operations, which is what is being implemented right now by CPDRC also in the management of the jail. Under conduct of search and seizure, paragraph 9, all inmates must be thoroughly inspected before they will be directed to proceed to the holding area. If deemed necessary, a strip search may be performed. And also in security and control procedures, Your Honor, in paragraph 9, if necessary, strip search may be conducted to inmates in accordance with the BGMP standard operating procedures. And paragraph 10, inmates at the holding area must be made to remain seated with their backs turned on personnel, which they must likewise be directed to keep their heads down, that they may not be able to observe the movements of the operatives. And that is what we have been doing, sir, Your Honor.
But it appears that in line with what the Honorable Del Mar is asking, it is not in conformity with Section 14, Republic Act 9745. It still is an inhuman treatment. Anyway, so as to put things on focus, the Cebu Provincial Detention Center is under the supervision of the provincial government. The head there is the warden. And the warden is appointed by the provincial governor. And the warden we have now is an appointee of the provincial governor.
Mr. Chair, we have an acting warden in the person of Mr. Legaspi behind me. We don't
where is
have yet
Mr. Legaspi?
a warden, a permanent warden.
Will you please take a seat here, since we have, you are a person of interest. Yeah. What, with the permission of the Honorable Delmar, what steps have you taken to see to it, number one, that the detention prisoners are properly treated? Do you have a holding room as asked by the Honorable Delmar?
Are we talking about the day of the raid, February 28?
No. I'm talking about the possibility of the need again to require the detention prisoners to strip. And in light of the right to privacy, they have to enjoy a detention or the so-called holding room. Do you have a holding room?
We do have a designated holding room, but the raid that actually we performed on February 28 as well as August 13 was actually a prison-wide Greyhound operation. So during the raid of February 28, it involved 2,700 plus inmates. So if we actually strip search the inmates in this certain designated cell, it would take basically 3 days to search.
How many detention prisoners do you have?
As of today, as of Friday, our report was 3,017,
And
increasing every day.
How many personnel do you have?
We currently have 133, but we only have 60 guards, prison guards. So we're undermanned. The prison was actually built for 1,500 inmates. We're actually over 100% right now. We're overpopulated.
Okay, you're overpopulated. Nonetheless, do you have a space by which these detention prisoners are being searched could be made to strip without exposing them?
If we talk about a small number of, if we do, for example, a mini Greyhound, certain number of cells.
I am not talking about any raid yet. No?
Oh, okay. For
And I'm not even talking about the raids conducted.
Okay.
I am talking about your operational requirements, the needs of the detention of CPDRC.
CPDRC.
So, what is the area of CPDRC?
We're at 30, I believe 35,000 square meters.
Is there still an open space which you could use as a so-called strip search area?
Yes, we currently we employ, we have, for example, when visitors come in, we have a designated room for males as well as females visitors. So yes, we do have designated areas for strip searching, but not for that big number, 3,700 inmates. 3,000 plus inmates that we have currently.
These 3,000 plus detainees are both male, female?
Currently, we have close to 200 females now. The rest are males.
Are the female detainees also being stripped in public?
No, they're not.
Only the boys, only the male?
On a regular search, they're done in private, in a room, in a designated room.
When you say regular search,
when they're going out to court hearings, when they come back from court hearings, or
they are being stripped?
Strip searched in a private room.
And when you say in private room, is it one room versus one person being
Correct.
stripped?
One PNP inspector versus one inmate. And then when it comes to the female PNP inspecting a female inmate.
when you say raid and you have to require 3,000 detainees to strip themselves, this is because of lack of time to go through a one-on-one strip search.
I think it's more that plus the safety of the raiding individuals. Like Sir Yogi Ruiz said, just one instance, if one inmate started something, he stabbed somebody or wanted to fight, that becomes a riot now, and that actually, for example, that day of the raid, we only had 270 personnel there versus 2,700 plus inmates, and you can, they could overwhelmingly take over, the law enforcement agencies.
Warden, can you enjoy the luxury of confining the detainees that far, camera, and you would be standing here?
I don't get your question, sir.
Okay, halimbawa magre-raid ako.
Okay.
Maraming tao. Ang concern mo lang naman hindi kayo masaktan. Pwede ba natin sa pagsabihan yung mga detainees, doon kayo, mga 30 feet away, maghubad kayo doon. Makikita mo kung sino ang may gamit o wala.
Actually, everybody during that raid had their designated responsibilities. PDEA, their responsibility was for searching the cells. PNP, together with designated inspectors with the PNP, pero most of the armed forces personnel were used as security, so they provided the peace and order during the raid.
I am about to turn over the questioning to Honorable Delmar, but let me ask you 3 questions.
Yes, Chairman.
Again, you're the warden.
The OIC. Sir.
OIC.
Officer in charge.
CPDRC. Warden. And for how many months already?
I started March 1 up to the current date today.
So about 2 months.
2 months, sir.
Are there talks about drug proliferation in CPDRC?
Aside from the February 28 raid that we incurred, we actually had 4 other raids, mini greyhounds. So
I am talking about the 2 months that you have been an OIC warden.
There is contrabands there. There are
drug proliferation.
I don't think what we're seeing right now, I might be wrong, but what we're confiscating now is really minimal. The last mini greyhound that we did was on the cells of high value targets or high profile inmates. We did one on the same day we had
how many high profile targets do you have?
During that last raid we did, we had 2 individuals which we actually confiscated zero methamphetamine. We thought we had
You mean you were not able to find any shabu?
Shabu, but we did confiscate cell phones.
But drug trade can be made even in the absence of shabu.
Yes, I understand
through
that.
Cell phones.
Yes, but what we're seeing during the past many raids that we're doing, it's in a smaller quantity. Doesn't mean it doesn't exist in there.
Yeah, but do you have, the reason why I'm asking quick questions is because I don't like to delay the questioning of Congressman Delmar. Do you have do you have personalities in CPDRC of the like of J.B. Sebastian?
Yes, we do.
Management lang kasi itong akin bago bigyan
Yes,
ito.
we do.
And
We
what steps have you taken to check the drug trade of these suspected drug personalities?
We're actually, I'm working closely with with Sir Yogi, with Padilla, as well as the intelligence officers of the Cebu Provincial Police Office. So I'm getting directions from there. But we have them under actually.
That would be all. I now turn over the questioning to
Thank you, Mr.
Honorable
Chair.
Delmar.
Because getting impatient, the Deputy Speaker is getting impatient. He's following me after my turn. So, leaving this stripping thing aside, maybe now that the warden is here, so that, you may be charged and kawawa naman kayo, no? For cruelty and all. So, maybe you should install some improvement there. So you'll be conducting more raids and you'll be asking them to strip again. So maybe, can you take a look at that walkway there outside that has a roof? If at one segment in the center you can put walls and make the inmates pass it. You don't have to, you will not waste time. They just pass and walk through, and when they are through that sheltered area, then they can be, the search can be expedited. But we're no experts. We're just looking at how we can improve things, Warden. So, since I have no length of time to get my questions in, let me just move very quickly on other questions. So, Warden, assuming that PDEA Chairman Ruiz is held responsible for cruelty and inhuman treatment of this incident, you will also be blamed because you are managing the jail. Isn't that correct?
Yes, Your Honor. Actually, I was there. I was actually the point person for the province of Cebu. Governor gave me the responsibility of coordinating the Greyhound operation with Padilla as well as the PNP. I was there when Sir Yogi suggested during the last meeting that when we talked about the protocol and how would we raid.
Okay,
he
so
talked about,
you agreed to the procedure.
I agreed
that
to
they
it.
were going for.
Yes.
Did you relay the procedure to the governor and ask him whether it's all right with him?
No, no, I didn't. It was actually the day of the jump off of the.
So you assume responsibility.
I assume the responsibility.
So I know you're appointed by the governor. You probably will answer that the governor is not responsible. But if you are wrong, you're the one managing. Do you think you didn't consult the governor? Do you think the governor should be blamed for for your wrongdoing, your bad judgment, for your offense?
Your Honor, I don't think it was a bad judgment. If you were surrounded by 2,000 inmates, you could feel the. If you're not used to it.
If so, I'm not saying that it was bad judgment. If in the event that you are held liable for this, because as you said, you're part of the decision on the stripping.
I would take full responsibility.
Yeah, but my question is, can you pinpoint to the governor that command responsibility because of the fact that he appointed you as warden to take care of the things at the jail?
I understand command responsibility. Command responsibility falls in place. I think, lack of better judgment, I didn't inform him. But I would think, a regular person put up against this situation. We weren't pressured for time, but we really wanted to make everything run smoothly. We didn't want the inmates at the same time, for their welfare, to be exposed with the sun. So we tried to finish this in a certain number of hours. We finished, I believe, the inspections by 4 a.m. We started approximately, I believe, 1 a.m. So considering what the time constraint and the number of personnel in the raiding team, I think we did it expeditiously. We did it carefully. We also had, we thought we had more canine units. We tried to request from the Coast Guard, but they declined our request. So we only had two canines to help us during the raid, together with the manual inspection. So we were pressured. We didn't want the inmates to start.
We get the point. Because I'm sorry to cut you. Because they're getting more impatient. No. So let me just go to my last point. I'm sure the former governor, now Congresswoman, now Deputy Speaker, has intention is just to suggest, in bringing this to suggest that things be improved, so that everything can be in working condition. There will be less illegal drugs being brought in and out of the jail. But to me, I've known the governor also for quite some time, Congresswoman, and I think he shares your concern. So my point is just that I can see that the events, that what happened, the things, the illegal acts or immoral acts that are being done in the jail should be blamed at most to the jail warden. I don't think the government should be blamed for your decisions there, right?
Yes, Your Honor.
Okay, that's just my point, Mr. Chairman, and I know that to put things in proper perspective, I'm just as close a friend to the governor as to the Congresswoman, I hope. And maybe I can also, for the record, Governor, isn't it that you are one of 10 honor list governors to be cited for stemming the illegal trade in their respective provinces?
Well, that's according to the newspaper, Mr. Chair, sir. But there's been official, official recognitions.
Yes.
This was just announced by then Secretary Sueno.
Yes.
Yes.
Thank
yes,
you.
sir.
Because this is, in fairness to
Yes, sir.
Congresswoman Garcia, she cited this in her speeches. Likewise. Okay. Thank you. Man, may I just
Yes.
have the opportunity to ask more questions after everyone is through? Thank you.
Mr. Chair, just for the record, because my esteemed colleague, the distinguished congressman from the north of Cebu City, has constantly referred to me as well as our governor. This is in fact the reason for this inquiry. No one is blaming anybody yet. My questions are in fact raising the issue of who is to blame. And perhaps it might be premature, even at this point, to lay blame on anybody or ultimately exonerate anybody. Because we are still investigating and we are still trying to ferret out the truth. So thank you, Congressman, and thank you, Mr. Chair.
Next is the most handsome guy around.
Next to you.
Okay. Deputy Speaker Castro. Thank you for the compliment, Mr. Chairman. But I understand that if you are considering me to be the most handsome, perhaps I am next to you. In any event, Mr. Chairman, I have only few questions. The regional director is Regional Director Talino. Am I correct, General?
Yes, Your Honor.
As a general or regional director, you are aware that you have your staff standing operating procedure in the PNP whenever raid is conducted. Am I correct?
Yes, Mr. Chair.
And that standing operating procedure relates to handling of inmates whenever raid is conducted inside the jail or provincial jail, city jail, or whatever jail it may be. Am I correct?
Yes, Mr. Chair.
I will leave you there in the meantime. I will now direct my question to Mr. Robert Legaspe. I understand that you are the provincial warden, Mr. Legaspe?
I'm actually the OIC, officer in charge.
But no, let's disabuse ourselves. Whether
Yes, Your
you
Honor.
are an OIC or a permanent one, but my question is, you are the provincial warden.
Yes, Your Honor.
Okay. For how many months before the raid?
Effective March 1,
March 1 of 2017.
2017.
Are you aware that whenever being the provincial warden, are you also aware, like the PNP, that whenever raid is conducted, especially inside the jail, provincial jail or otherwise, there is a standing operating procedure on how to handle inmates. Am I
Yes.
correct?
Yes.
Okay.
Yes, Your Honor.
Now I will go to PDEA. You are Director.
Yogi Ruiz, Your Honor.
Come again?
Yogi Filimon Ruiz, Your Honor.
Ruiz.
Yes, Your Honor.
Okay. Like the PNP and the provincial guards of the provincial government of Cebu, you also conduct raid, isn't it, Director?
Yes, Your Honor.
And considering that PDEA also conducts raid, you also have your SOP or standing operating procedure, especially in the handling of inmates during the raid. Am I correct?
Yes, Your Honor.
My question to you is your SOP in handling inmates in times of raid the same as that of the PNP?
The standard operating procedure being followed by PDEA in cases of raids in the jail, Your Honor, is the PDEA and BJMP manual of operation, Your Honor.
I am not asking, Director, whether it's the same. No, I am not asking whether you are following your SOP or you are following the SOP of the PNP. But of your own knowledge, could you please advise the committee on whether your standing operating procedure is the same as that of the PNP whenever you conduct raid in jail or provincial jail or any jail for that matter?
It is the same, Your Honor.
The same. I will now go to the provincial warden. Is your standard operating procedure in handling inmates in case of raid in jail, in this particular case, the provincial jail, the same as that of the PNP and the PDEA?
Actually, let me clarify. As effective last week, the provincial board approved the operation manual for CPDRC. So during that time, we actually did not have an operation manual for CPDRC. We basically referred to the BGMP manual or the Bureau of Corrections manual.
Are you more or less familiar with the standard operating procedure of the BGMP?
Actually, to be honest, after the raid, I reviewed the BGMP manual.
Okay, in any event, was the raid conducted in Cebu Provincial Jail?
Inside Cebu Provincial
Yeah,
Jail.
inside provincial Cebu, inside Cebu Provincial Jail. A joint raid between the provincial government through the provincial guards or provincial warden, the PNP, and the PDEA.
And AFP.
And
AFP.
AFP. This was a joint raid.
Correct, Your Honor.
Now, considering that it was a joint raid, could you please tell us whose standard operating procedure was followed at the time of the raid?
During the February 28 raid, Sir Yogi with Padilla was actually elected the ground commander because during that time, PNP were not allowed to actually do any operations for any drug raids. So basically, I left all the instructions via Sir Yogi, the Padilla.
Therefore, the PDEA was the lead agent
Yes, Your
when
Honor.
the raid was conducted in February 2017. Is that correct?
2017.
2016.
Yes, Your Honor. 2017.
2017. And is my impression that considering that PDEA was the lead agent when the raid was conducted, am I correct to say that the PDEA standing operating procedure in the treatment of inmates was followed during the raid?
Yes, Your Honor.
Okay. My question now is, I want PDEA to answer this. Stripping naked the inmates during the raid, was it part of the standing operating procedure of PDEA?
Yes, Your Honor.
Can you show to me the manual which states that stripping naked the inmates during the raid is part of the standing operating procedure of PDEA during the raid?
Yes, Your Honor. I have it with me, Your Honor.
Can you read it?
Based on the PDEA BGMP Manual of Operations in the conduct of search and seizure of dangerous drugs, controlled precursors, and essential chemicals, and drug paraphernalia in the jail facilities, as approved last 20 January 2015 by Undersecretary Arturo Cacdac Jr. and Jail Director Johnny Mamaril, under conduct of search and seizure, paragraph 9, all inmates must be thoroughly inspected before they will be directed to proceed to the holding area, and if deemed necessary, a strip search may be performed, Your Honor. And under security and control procedures, paragraph 3, the authority of the ground commander is absolute. Irrespective of the hierarchy of command, no directive shall take precedence or overrule the authority of the ground commander over the operation until his or her relief. And on paragraph 9, if necessary, strip search may be conducted to inmates in accordance with the BGMP standard operating procedures. And on paragraph 10, inmates at the holding area must be made to remain seated with their backs turned on personnel. They must likewise be directed to keep their heads down, that they may not be able to observe the movements of the operatives, Your Honor.
Before the Deputy Speaker proceeds with further questioning, I would like to throw a caution to you people. Okay? Article 2 of our Constitution says we have adopted the generally accepted principles of international law as part of the law of the land, meaning provisions in international conventions are deemed provisions in our laws, in our Constitution. Now, I have here from this paper from the CHR in relation to this secret detention cell. It says in Article 10 of the ICPR, this is an international convention, civil political rights. It provides that all persons deprived of their liberty shall be treated with humanity and with respect for the inherent dignity of the human person. Article 7 says of the ICCPR, no one shall be subjected to torture or to cruel or inhuman or degrading treatment or punishment. What worries me here is that you have in the Anti-Graft and Corrupt Practices Act, Section 3E, the moment under international law, which is now part of the law of the land, the moment you direct detention prisoners to strip, you have unduly caused upon them undue injury. Section 3E speaks of undue injury under the Anti-Graft and Corrupt Practices Act, and you people will be subjected to violations of the Anti-Graft and Corrupt Practices Act, especially that you have already admitted that this is a part of your standard operating procedure per manual, which the PDEA Regional Director just read. I am very much worried about that because you PDEA people, you PNP, you Warden, and worse is, including the government, are risking themselves into not only civil suits but criminal suits as well. I am interjecting this point of law in order that as much as possible we no longer touch that matter, with the permission of the Deputy Speaker.
I think what the chairman is trying to imply is you should be more cautious about your answer to my question, which you might find innocent because you are going through the pit of incriminating yourself through admission. But in any event, I would like to continue, Mr. Chairman.
Go ahead.
During the raid, was there any agreement between PDEA, the provincial warden, or any of his agents, and the PNP that PDEA will be the lead agent?
Yes, Your Honor. There was agreement that PDEA will be the ground commander, Your Honor.
Therefore, the raid was under the control and direction of PDEA.
Yes, Your Honor.
Now, considering that it was under the control and direction of PDEA, even stripping the inmates was also upon the control and direction of PDEA.
I was just basing it on the PDEA and BJMP manual of operation, Your Honor.
Let's not talk about that manual. I am now talking about direction. You may give your direction on the basis of that manual, but it is PDEA that gives the direction that the inmates should be stripped. Is that correct?
Yes, Your Honor.
And on the basis of the raid conducted, could you please tell the committee on whether it was conducted in accordance with your manual, considering that your manual states that they should be brought in a room, 2 or 3 of them, but not in mass?
No. There is nothing states in the manual, Your Honor, that they be brought into a room, Your Honor. If you take into consideration, Your Honor, the size of the area to be raided and the number of inmates that have to be inspected, there is no, upon perusal of the floor plan of CPDRC before the raid, it took us weeks before we conducted the raid, Your Honor. There really was no area that was capable of holding by cell the number of inmates in CPDRC. If we would have done that by cell, it would have we conducted a computation, Your Honor. It would have taken us 3 days to accomplish the entire task, Your Honor.
Okay, I will follow you, Director. Considering that the manual is silent as to whether it would be conducted individually, in cluster, or in mass, the raid was conducted in mass and it was a judgment call.
The raid was conducted per cell, Your Honor. Every detainee per cell was made to come out already stripped so that they would have no area to hide any bladed weapon, Your
You
Honor.
are not getting my question. Since the manual is silent on whether the raid would be conducted by 2, by 3, by 100, or by 50, therefore conducted the raid in a manner that you did during the raid was more of a judgment call.
It was based on the, it was not a judgment call, Your Honor. It was based on the manual of operations, Your Honor.
What does the manual say? Does the manual say it shall be conducted in 20, in 50, by 100?
It does not say, Your Honor.
Therefore, since the manual does not say in 20s, 30s, 40s, or 50s, your procedure and the conduct of the raid was more of a judgment call. Am I correct?
It was a judgment call based on also on the taking into consideration the safety of the raiding team and also of the prisoners, Your Honor.
That's why it was a judgment call.
Yes, Your Honor.
It was a judgment call because your intention was to conduct an effective and successful raid. Correct?
Yes, Your Honor.
And to your judgment, raiding in such a manner would give you a very successful raid during that time.
Yes, Your Honor.
That's it. At least we understand each other. Because your tendency, whenever you are being asked, is to be evasive. But you don't know but that by being evasive, you are committing mistakes. I think that's all, Mr. Chairman.
The next is the Honorable Garcia.
Thank you, Mr. Chairman. I will be very, very brief, considering that, in fact, I was supposed to be in another meeting about 30 minutes ago. But to show my appreciation for the presence, especially of the Governor, Board Member San Shimura, being very busy people, I will just ask a few questions. I direct my first question to pick up from the questioning of our, as stated by Congressman Veloso, a handsome Deputy Speaker, most handsome. May I first clarify this with Regional Director Yogi Ruiz? I understand you took full responsibility. You ordered the stripping of the prisoners.
Yes, Your Honor. I was the one who gave the order to strip, Your Honor.
You are very sure of that?
Yes, Your Honor.
Well, I have here a news item dated March 5, 2017. And this is from the ABS-CBN News. I shall read this. PIDEA spokesman Derek Carrion said, the stripping of the inmates was on the order of the provincial governor and the guards, while Provincial Government Information Officer Jethro Bacolod said the mass stripping was an SOP, or standard operating procedure for raids to detect contraband. Further, from the Inquirer.net, dated even earlier, March 2nd, 2017. And I shall read this. Again, Provincial Government Information Officer Jetro Bacolod told AFP the mass stripping was an SOP, or standard operating procedure for raids to detect contraband. So my understanding from these two news items is that it was not the PIDEA that in fact ordered the raid, because PIDEA spokesman Derek Carion has specifically stated in this particular news item entitled Malacanang Questions Spread of Photos of Naked Inmates. Your own spokesman, Mr. Carion, has pointed to the governor as having ordered the stripping of the inmates. May we please have a clarification about this?
Your Honor, I have with me Director Derek Carion of the PDEA Public Information Office, Your Honor.
With the permission of the Honorable Chair, sir. Madam, Your Honor and Mr. Chair, I was interviewed by media that day. Of course, not being in the area, I sought information from Director Yogi. But actually, Madam Chair, under no circumstance did I specifically say that the strip search was ordered by the Honorable Governor. And in fact, what my answer to media was that any movement done in the provincial jail is coordinated with the provincial government, but PIDEA is the lead during that time, Madam Chair. So perhaps it was not picked
You
up.
are disputing this report from ABS-CBN as well as reports from Agence France Presse.
Yes, Madam Chair, because I clearly stated that PIDEA came in providing technical assistance, being the lead anti-drug agency.
Did you state that it was PIDEA that ordered the stripping of prisoners?
I did not state that perhaps, Ma'am, directly.
But I believe that the question was who ordered the stripping of prisoners. There could only have been two answers.
Yes, Madam
Either
Chair.
the provincial governor or PIDEA.
Yes, Madam Chair. My exact reply was that PIDEA was the ground commander.
So there
I
was no
will-
answer to the question of who ordered the stripping of prisoners, or are you now discounting what you actually answered?
Madam Chair, I was not actually asked as to who ordered the search. They were just asking us as regards to...
Garcia, let me just interject.
Yes.
You said coordinated.
Sir?
You mentioned
Yes, Mr. Chair.
coordination.
Yes, Mr. Chair.
Coordination between and among whom?
Between the provincial government and PIDEA, Mr.
And
Chair.
when you say provincial government, you're talking to reconcile the position taken by the Honorable Garcia. It is the provincial governor.
I'm sorry?
Coordination between the provincial governor and
PIDEA, Mr. Chair.
Okay. So when you say there has been a coordination, will you tell the committee if there has been an attempt on the part of the provincial governor to stop this stripping?
Mr. Chair, I would not be competent to answer the question because, as I said, Mr. Chair, I was not in the area, so I have no knowledge on the actual conduct
The
of
governor
operation.
is here, Governor Davide. Do you confirm what Mr. Carion said, that there has been a coordination between PIDEA and the governor in regard to this?
As regards the stripping of the inmates, Your Honor?
Yes.
No, because my specific order, in fact, prior even to the Operation Greyhound, I wrote PIDEA, Director Ruiz, requesting him to conduct an Operation Greyhound in light of so many reports I received on the alleged on drugs being smuggled into the facility. That was it, Your Honor.
And that was in writing?
That was in writing, Your Honor.
Can you show us the communication?
It's this is dated February 8th, Your Honor. I signed this. This is a memorandum addressed to the acting jail warden then, Dr. Hil Makato, and the guard on duty, which the substance of the letter is states that this is to authorize Cebu Provincial Police Director Police Senior Superintendent Eric Noble and PIDEA Regional Director Yogi Filimon Ruiz and their respective teams to conduct Operation Greyhound in and around CPDRC on February 22, 2017. Second paragraph, all CPDRC officers and personnel are hereby directed to provide full cooperation and submit a report on the operations conducted for strict compliance. And then my name. Actually, the raid was conducted on February 28th, 6 days after I issued this memorandum. I figured, Your Honor, that the PIDEA, the PNP, had to coordinate and in order to plan the operation.
Honorable Garcia.
Just to go back to Mr. Carrion, remember you are under oath.
Yes,
Are you
Madam
now
Chair.
categorically denying that this report from Agence France Presse and ABS-CBN dated March 5, 2017 is in fact erroneous and that you never
Yes, Madam
stated that the stripping of the inmates was on the order of the provincial governor and the guards?
Yes,
Are
Madam
you
Chair.
categorically denying this?
Yes, Madam Chair.
Mr. Chair, may I now manifest that since this hearing cannot conclude with one sitting and we foresee further hearings, that we summon the reporter who actually wrote this ABS-CBN report. Further, Inquirer.net states, by the way, the same Jetro Bacolod, who is the provincial information officer, in this particular report by Agence France and ABS-CBN reinforces what you now state is a false claim, that it was the governor that ordered, because the next sentence states that Provincial Information Officer Jetro Bacolod said the mass stripping was an SOP. Logic would dictate, Mr. Chair, that the reporter would have wanted to confirm the statement of Mr. Carrion by then going to the provincial government and asking the provincial information officer whether in fact the governor had ordered, and the answer of Jetro Bacolod quoted in this March 5, 2017 report by ABS-CBN and Agence France was it was an SOP, reinforced by an earlier report by the Inquirer.net, wherein again Mr. Jetro Bacolod from the provincial government, he is the provincial government information officer, this time told the AFP the mass stripping was an SOP, or standard operating procedure for raids to detect contraband.
Anyway, the interview was recorded, Mr. Carrion.
Yes, I believe so.
Mr. Chair, I was called over the phone, so I would not know, but perhaps they might have recorded. I am not sure, Mr. Chair.
Okay.
Just to honor the fact that both our governor and the provincial board member is here, may I now ask the honorable governor, Governor Davide, and I have other questions, but just for brevity, for lack of material time, I would wish to focus on this for this hearing, on Mr. Toral. Mr. Marco Toral. I have here 2 interviews conducted by our 2 local dailies where he calls himself the prodigal father that returns to serve, and by all accounts and purposes, his appointment as a jail management consultant, or a security consultant for that matter, was indeed justified. In fact, we are talking here of ironies because he himself had been charged under the Dangerous Drugs Act and had been convicted by the regional trial court, sentenced to life imprisonment, served for 8 years, and then was subsequently out or released upon reversal, as he claimed, of his case. I understand that Mr. Toral was a schoolmate of yours?
Not really, ma'am, but I knew him since college.
Oh, I'm mistaken. In this article, he claims that he was a classmate of
A classmate
your wife.
of Mrs. Davide, ma'am. In
Jobel.
UP Cebu.
Jobel.
Yes, yes.
What was the course that he finished?
I'm not quite sure, but my wife took up BS management at UP Cebu. He probably had the same course.
I see. As jail management consultant, would you say that he was in charge of security as well?
Yes,
right?
ma'am. Yes.
And so that, in a sense, because you had made reference to this representation that I had hired my own brother as security consultant, then he would fall under the implementing rules of Republic Act 5487, which defines government security personnel, which states that government security personnel shall be natural persons, which include government security guards, detectives, security consultants, security officers, and others that may be classified later. There are exceptions, of course, those that come from the armed forces, from the PNP, from the BJMP, and municipal or city jail guards that are rendering or performing security. Was he ever a member of the AFP or the PNP or the BJMP?
To the best of my knowledge, no, ma'am.
And so that Rule 5 further states that there are certain qualifications of security consultants. So the only way that a security consultant may serve in any government entity would be for him to have a security license.
I'm not quite sure. I cannot really answer that, but I got Mr. Toral precisely because I knew him. He's a friend, and he had some experience as an inmate, and specifically on
yes, the ironies of it.
Yes, so he said that when I got engaged him, he said, I pledge to really help your administration and cleanse the CPRC of drugs. He knows the ins and outs of the jail. Befriended, of course, during the time that he was consultant. Befriended some inmates there.
Yes, well, that is. I understand your position, Governor Davide. You know, it's lonely up there in the top. You need people whom you can trust. But then, as official keeper of the jail, I had read this earlier, the administrative code specifically states that as keeper of the jail, the governor shall be charged with keeping of the provincial jail, and it shall be his duty to administer the same in accordance with law and the regulations prescribed for the government of provincial prisons. So I had just stated earlier a particular law, Republic Act 5487, which states that no person shall be licensed as a security consultant unless he possesses the following qualifications. And these qualifications are set forth: Filipino citizen, physically and mentally fit, holder of a degree, master's degree in criminology, public administration, or an equivalent thereof, must have at least 10 years experience in the operation and management. So you are not certain whether he was ever issued a security consultant license?
No, ma'am. And I did not also ask him to present any, because as I've mentioned, I just got him as consultant.
And
Not as an organic member or employee of the provincial government.
yes, but even then, under Republic Act 5487, definition of government security personnel includes security consultants, and security consultants are subject to Rule 5. Now, if you are not sure, therefore, perhaps we may ask Mark Toral, which, Mr. Chair, I shall manifest to invite in the next hearing. And just for clarification, since the good governor has kindly mentioned that in keeping with what I had earlier practiced, that I had hired my own brother as the security consultant of CPDRC, well, he is present, and by the permission of the chair, may I ask Mr. Byron Garcia if you do hold a security license? Yes. Consultant license? Please stand up. May I request the chair to allow, and may we have him administer?
Kindly take that chair.
No, and
Mr.
to
Chair.
administer.
Mr. Chair,
kindly administer the oath.
Mr. Chair, with the permission of the chair and Congressman Garcia,
Go ahead.
I really have to go to the bathroom. I need to use the bathroom. I'll be back in 1 minute.
Yes, please.
Thank you.
May we request you to administer the oath?
Please raise your right hand. Please state your name and your position or designation.
I am Mr.
Yes.
Byron Garcia.
And your position.
I'm a consultant now for Congressman Gwen.
Do you swear to tell the truth, the whole truth, and nothing but the truth before this proceeding?
Yes, sir.
Let me take your seat.
I just have one question. When you served as security consultant during my term as governor of Cebu, did you hold a valid security consultant license?
Yes, Your Honor. In 2004 until 2010.
Is that a matter of record at the PNP?
Yes, Your Honor. You can check the record at the PNP.
That is all that I wish to ask of Mr. Byron Garcia. Mr. Chair, I shall now direct, thank you. I shall now direct my question to Provincial Board Member San Shimura.
Go ahead.
As I had stated earlier, Board Member San Shimura was chair of the Committee on Peace and Order from the year 2010 and up to the present. Is that right?
Good afternoon, Mr. Chairman. Good afternoon, honorable members of this inquiry. Yes, yes, Mr. Chairman. I am part of the last term of now Congresswoman Garcia and the present Governor, Hilario David III.
So that when all of these things, anomalies that were being exposed by media came out, even as far back as July 2014, and on to 2015, about inmates, well, one particular inmate, Mr. Noel, without court order, brought to the Cebu Doctors Hospital by Mr. Toral himself, about illegal drugs being smuggled into the CPDRC and drug trade proliferating, about even child pornography, cyber pornography happening inside the CPDRC, as claimed by Vice Governor Agnes Magpale. Did you call for an investigation?
Yes, that is true, Mr. Chairman. When I heard about the news that there are certain issues inside the CPDRC, I filed a resolution asking for Sir Marco Toral. During that time, he was the consultant, the governor, and also the warden, who is Mr. Manansala. The resolution was all about, first, there was death of 8 inmates during that time, in the whole month of July. One inmate who is linked into drugs, a certain Mr. Arnel Mait, escaped during daytime, and a certain inmate also who got fractured during a basketball game inside the CPDRC was brought outside the center without any court order. So that's why I called up the attention of the warden and Mr. Toral, Mr. Chair.
So when you called for an investigation, was an investigation subsequently held by the provincial board?
Yes, Your Honor. But actually, when I requested the appearance of the two, only Mr. Manansala, the warden then, was there, and there was no Marco Toral who came during the inquiry.
Why was he not there when the provincial board had requested for his presence?
The request was made during August 15, if I'm not mistaken, August 15, 2016, and
was this after the
yes.
August 13 raid?
Yes, Your Honor. And the reason why Marco Toral did not appear in that inquiry was his contention was he already resigned during that time.
But there were a lot of issues hounding Marco Toral, including the renting out of conjugal rooms. As claimed by Vice Governor Magpale, renting it out for as much as 20 to 30,000 per month without knowledge of government. There were also other issues as regards drug proliferation and even Marco Toral firing shots inside the provincial jail. If he did not appear, was that enough that just because he resigned, he no longer needed to appear?
Well, actually, Your Honor, the inquiry was about, yes, the firing of the blank cartridge and then the death of other inmates and the escape of Mr. Mait. But then some issues came out during the inquiry, which also the Vice Governor had put on the table during that time. First, that was, yes, it is true that there is a red car with no plate number going in and out of the center during midnight.
How did you get this information?
This was stated by the warden then, Mr. Manansala, Your Honor.
And this red car, who owned this red car?
This red car was allowed by Mr. Toral. That was stated by Mr. Manansala, Your Honor.
What else did you learn from Mr. Manansala?
Aside from that, there's this conjugal room, which is fully air-conditioned, being rented for 2,700 per day. This is also allowed by the consultant then, Mr. Marco Toral, Your Honor.
And was it specifically stated that rental does not accrue to the provincial government but pocketed by Mr. Toral?
Your Honor, it was stated by the warden that it didn't have any receipt from the provincial government.
Are there other issues that were taken up during your investigation?
Yes, Your Honor. The contraband, especially during then there was an inmate which was captured for child pornography, who was during the raid they got laptops and other contrabands, Your Honor.
So I will ask again my question. Mr. Toral did not make an appearance. What was the action of the board? Since there were very serious issues that were hounding Mr. Toral.
Your Honor, we were just clinging on the statements of Mr. Manansala, since the governor already approved also the resignation of Mr. Marco Toral.
Well, resigning is one thing, but having to account for certain alleged actions is another thing. So did the provincial board decide that they would just let go of Mr. Toral?
Yes, Your Honor, since the governor also stated and released a statement that he is creating a task force for the investigation of all these happenings inside the center.
And so I repeat my manifestation, Mr. Chair, that in the next hearing, we shall be requesting for the presence of Mr. Marco Toral, whom the governor has described that continues to be a good friend. And we can probably get the address from the governor himself so that Mr. Tural will be notified of our invitation.
Yes, ma'am. We will gladly furnish the subcommittee the address of Mr. Tural. I will personally contact him.
We thank you really
And maybe
for...
you would also want the presence of the former acting warden, Manansala, if...
Yes, certainly. Well, I shall be submitting to the Secretariat more names that will be invited. Yes, as you had mentioned, Honorable Governor, the former acting provincial warden, Mr. Vicente Manansala, and other names that have cropped up, which I can be submitting to the Secretariat. That will be all, Mr. Chair. Thank you very much.
Okay. Thank you very much, the Honorable Deputy Speaker. Are there any other resource persons that you would like to be invited other than Mr. Tural? Honorable Deputy Speaker? Okay, please submit it to the committee secretary. The Honorable Ching Veloso is recognized.
Thank you, Mr. Chairman. A few questions, though. First is, again, to the warden, Mr. Legaspi. What work did you have before you became a warden?
Actually, my position is actually head of the CSU, Civil Service Unit of the province of Cebu. So still with the province, under the administration of Governor Davidi.
And before that, you were?
The U.S. Air Force.
You were the Air Force?
Yes.
As what?
Dental manager, senior NCO, master sergeant.
General manager of?
No, dental manager.
Dental manager.
Yeah.
Meaning you never had any administrative employment before that? You did not have any work related to administration of a particular unit?
Of the province of Cebu? Or
before you became...
out of the Air Force.
Out of the Air Force, what happened to you? You were with CSU?
No, actually, prior to that, I was working for my sister's school. I was the one of the school administrators.
Tell me if at any given time you had the occasion to manage a big enterprise.
No, I did not.
Not even small enterprises.
When you talk about enterprise, I was an administrator under my sister's school. So...
You were the administrator?
One of the administrators.
Why? How many administrators does that school have?
We had on the recreational side, I had nothing to do with the curriculum. It was on the recreational side, PE activities, after-school activities, the security of the school, the compound of the school.
Not the way you describe it, you actually were not an administrator then.
That was my designation.
You were designated as administrator, but you did not perform the task.
Not as a school, not as the as a curriculum administrator.
Not even as an office administrator.
No, I did not.
In short, the reason why I'm asking that is you were appointed OIC warden of CPDRC when you have never been an administrator of any agency, private or public.
Correct. I have no, actually, I have no competency in jail management, if that's what you're getting to.
Anyway, what steps have you taken to stop the drug trade, despite your lack of experience as administrator?
Currently, because of the situation of CPDRC, the location, we have actually houses outside across the street of the jail. We currently have, we weren't able to purchase high power cell phone jammers. We currently have, if you will, low power. We're still in the process of adding more, so we're doing it by sectors because, of course, Governor Davide does not want to affect the neighbors. If we get a cell phone jammer that's actually for prisons, it's going to affect the whole neighborhood. So what we're doing we're doing it in stages. So we're dividing the jail into sectors, if you will, 4 sectors. Currently, we have 2 sectors that have the cell phone jammer. So we will be adding additional in the future.
So you have copied the scheme of New Bilibid Prison?
They actually have a high-powered jammer. We actually cannot go that way because we do have civilian living outside of the jail. So that's why I said low power. So we're looking at the areas where they're covered. Currently, the inmates that we've actually indicated are high value or high profile. We've put them underneath the jammers so they cannot use their cell phones. Of course, if they go to other areas of the jail, they can, but eventually we will cover that by the end of the year.
That would be all.
Oh, okay.
PDEA Regional Director Ruiz, did I hear you right when you said that as a matter of protocol, PDEA has to get the consent of the governor before you can conduct a raid?
As a matter of courtesy, Your Honor.
Courtesy or protocol?
What we have been doing, Your Honor, before we conduct any raid, especially in high-impact operations, we call it high-impact operation, Your Honor, because it will involve the whole facility.
My question is protocol versus courtesy, because if your protocol is enshrined in a manual, in a policy, you can be discourteous. You have to get the consent of the governor if that protocol is directed as a matter of policy in your manual. So my question is, do you have to get the consent of the governor as a matter of protocol?
No, Your Honor.
Oh, so it is not. Because the worst thing that can happen here is your governor will unnecessarily be put to task over something that he even doesn't know. Do you get my point?
Yes, Your Honor.
How many people do you have in PDEA Region 7?
I have 43 agents, Your Honor.
And I understand that anti-illegal drug enforcement is now the work of PDEA, not PNP.
PDEA is the lead agency in the anti-drug campaign, Your Honor.
Not only a lead agency, it is actually the work of PDEA, and PDEA has to get the assistance of PNP in undertaking particular assignment or mission. Is that correct?
Yes, Your Honor, it's correct, Your Honor.
Okay. Like the PDEA we have in Region 8, you are undermanned and underfunded. Is that correct?
Yes, Your Honor.
But you have submitted a request for additional funding, 2018 Jail Appropriations Act.
From the region, Your Honor, we have requested for additional personnel to complement, to reach down to the provinces, Your Honor.
Let me get this straight, no? If you receive an information or a tip that an illegal drug trade is being undertaken or supposed to happen, say, a week from now, the PNP cannot do anything but report to PDEA get the consent of PDEA before they can make any raid?
No, Your Honor. PDEA receives the coordination. PNP can conduct operations on their own, Your Honor, provided they coordinate with PDEA prior to the conduct of the operation, or if it is physically impossible to conduct the coordination prior to the operation, it should be within 6 hours after the operation, Your Honor, so that we can monitor the progress of the case, Your Honor.
Mr. Ruiz, you are contradicting yourself. A while ago, you said that you are the lead agency. Now, you are telling me, you are telling the committee that the PNP has to coordinate with you, meaning it can undertake a raid as long as it will coordinate with PDEA. So which is which? Coordination is different from your taking the role of a lead agency. Do you understand what I mean?
Yes, Your Honor.
So which is which?
PNP has the power to conduct their own anti-drug operations, Your Honor.
So it still has.
Yes, Your Honor.
Without the consent of PDEA.
All they need is to coordinate with PDEA, Your Honor.
Only to inform PDEA that we will be undertaking this raid, for example.
Yes, Your Honor.
Going back, the reason why I'm asking these questions is I don't like that what happened in Leyte will happen to Cebu, CPDRC. You know what I'm referring to.
Yes, Your Honor.
No names, because it can happen that, for example, the warden, I do not have to connect the warden to the provincial governor. It may be that the warden is a conspirator. I'm saying it may. I'm not accusing your warden now. No, it may happen that the warden is a conspirator in the drug trade. And here comes PDEA in coordination with PNP, or PNP in coordination with PDEA, whatever it means. Will conduct a raid. Will you inform the warden about that beforehand?
No, Your Honor.
So you can't conduct a raid without prior coordination with the warden?
Yes, Your Honor.
I'm not trying to defend the CIDG because it was wrong for anybody to say that no search can be conducted in a jail. If I know my rules of court, it says in any place, search can be made inside your car as long as you are equipped with a valid search warrant. Okay? So, because it's any place. Again, I'm asking this time, Director Talino. You have been the regional director of PNP in Region 7 for how long?
For 10 months already, Your Honor, because I was appointed as the regional director since July 1, 2016.
Yesterday, I was talking to informants. I am representative of the 3rd District of Leyte.
Yes, Your Honor.
We are just in front of Cebu, the eastern part of Cebu. We are western Leyte. We are facing Dambantayan, Carmen, Danao, eastern part of Cebu. And I was informed that especially Kalubian, Tabango side, and even in Villapa, where I come from, the drug processing activities in that area has increased, and that per reports, drugs are coming from Cebu. Of course, it could not have come from Sulu, no, or Apari. Neighboring area is Cebu. Are you coordinating with the regional director of Region 8 PNP on how you can block the drug trade flow from Cebu to Leyte? Because we have only how many? I think we are only 40 miles away from Cebu. In fact, in 1 hour, if you have a fast craft, you can be in Cebu. The supercut we have, it's in 2.5 hours. It used to be 2 hours. Are you coordinating with the regional director, PNP, Beltehar?
Yes, Your Honor, especially when there are some informations about illegal drugs trade between the two regions, we always coordinate with the other regions. There was one instance also that an operation was jointly conducted by Regional Office 18 and Police Regional Office 7 in Cebu area, sir.
About this Mark Toral, Mark Toral. I'd like to direct my question to the governor. Mark Toral has been a consultant only.
Yes, sir. Yes, Your Honor. Marco Toral.
Marco.
Yes.
Marco Toral. For how long?
When I assumed office in 2013, shortly thereafter, I got him as consultant, and then until his resignation in August 8 last year, Your Honor.
What made him your consultant? What considerations did you have in mind to make him a consultant?
Well, number one, his experience probably in jail. He spent 7 years in jail before the Court of Appeals dismissed his case. He was charged with a violation of the Dangerous Drugs Board. He spent time in Mandawi City Jail and then at the Narcom Rehab Center, also in Cebu City. And afterwards, he actually helped me in the campaign of 2010 and 2013, among other friends. We saw him as somebody who could really reform our jail system, the CPDRC, even when after I assumed office, we talked about improving the jail system, and he volunteered. He had actually many plans if given the opportunity. And when I decided to take him in as consultant, he pledged that he would commit himself to really improving the CPDRC and institute reforms there, as according to him, is very familiar with the ins and outs of jail facilities, Your Honor.
Do I get it to mean that his prior experience was that of a drug lord or what?
Well, I think he was caught in a buy-bust operation, Your Honor.
Okay, and
yes.
His experience precisely was as a drug offender.
Well, that's his experience in jail, and from our conversations, he said that in Mandawi City Jail, for instance, he was like a bosyo or a barang leader doon, and that's basically and what was the more important reason why I got him, because he was somebody I could trust.
Okay. You said he used to be a bosyo, meaning along the lines of J.B. Sebastian.
I'm not familiar with J.B. Sebastian.
You believe in the prison hearing we had, the Lima case. allowed the committee to discover how the new Bilibid prison was being run. And there we found that inmates became the administrators, in fact, of the new Bilibid prison. Administrator not in relation to really helping inmates improve their lot as detainees, but administrators in the drug trade. Of course, this was not the consideration you had when you got this Marco Toral.
Yes, Your Honor, of course not.
Okay. He happened to be only a friend.
A friend, a very good friend, as a matter of fact, Your Honor. And then, in fact, during his tenure as a consultant, there were improvements at the provincial jail. In fact, the inmates liked him, the way he handled them, the way he would address their concerns. In fact, during my visits to the CPDRC, I would talk to the Posio and even some inmates. They would tell me that compared to his predecessor, another consultant of my predecessor, they appreciated very much the work that Mr. Toral had done in the CPDRC.
Who is now your consultant?
Now,
in lieu of Marco Toral?
Right now, we don't have any. I decided not to get any more of the services of a consultant. We just have an officer in charge for the facility, Your Honor.
CPDRC is not overcrowded.
It is overcrowded, Your Honor. It was built originally for only 1,500 inmates. As of Friday last week, there are 3,017 inmates.
How are they being addressed?
We are actually building additional cells, 19 more cells, and I understand from the Bids and Awards Committee of the provincial government, contractors already been awarded the contract to build these additional cells, Your Honor.
Your inmates are detention prisoners.
Yes, Your Honor.
They are not convicts yet by final judgment.
Not yet, Your Honor.
That's the difference between a provincial jail and a correctional. Okay. Since what you have are only detention prisoners, meaning prisoners who are being detained pending litigation, pending final judgment. Have you, I am the chairman of the subcommittee on judicial reform. That's why I'm asking these questions. Because I would like to solve also that problem on overcrowding with courts coordinating with LGUs on how really to address this overcrowding problem. And one of that is if you have detention prisoners on account of petty crimes, do you have also prisoners, by the way, detention prisoners who are there on account of petty crimes?
Yes, Your Honor.
How many percent?
I have no figure
So
at
if
the
you
moment.
have 3,000, by the way, how many more or less?
3,017 inmates right now.
How many are there because of petty crimes?
Petty crimes. I don't have the
Sights
exact
and sounds.
figure.
Estimate 1/5, 1/4, 1/3.
Maybe a fourth, Your Honor.
So
most of actually the inmates are facing cases involving the violation of the dangerous drugs law.
okay, so if you say if that's 1/4, so that's more or less 750.
Right. Yeah.
There is a practice we have. a legal practice we have where people can take detention prisoners on recognizance. Have you put that into practice in your province?
Not actually, Your Honor. But I've been, as a lawyer myself, I tell these inmates that I get to meet to tell their lawyer to apply to file the appropriate pleading in court for them to be released on recognizance.
Okay, and you think that can happen?
That would be very helpful. That can happen, Your Honor.
And it's a matter of pressing the right button.
Yes, Your Honor.
Correct?
Thank you.
And
Yes.
all you have to do is talk
Yes.
to the court administrator, Midas Marquez.
Yes, Your Honor.
And all of a sudden, your 3,000 will be down to minus 750.
That would be a very big help, Your Honor.
Okay. But still, that would be short by a few. That would be all, Mr. Chairman.
Thank you, Your Honor. Thank you very much.
Okay, thank you very much, the Honorable Ching Biloso. Before the chair will declare a recess of this committee hearing, I would like to thank our source speakers, especially our governor from Cebu and the regional directors, Director Talino, Director Borjus, Director Ruiz, and Director Special Investigator Leo Villarino, and the Director of the CHR, and the other resource speakers, Mr. Legaspi, Director Arben Ordon is there, Board Member San, and then the representative of the Department of Justice, Attorney Genesis Gatdola. While I understand you have really waited for your turn to speak on all the issues that were discussed today, but considering the cooperations and the responses made by your previous representative, and no less than the secretary in the previous hearing, especially on the minimum age of criminal responsibility. So, medyo ngayon, while naghintay ka, nakapagpahinga ka to answer questions. Thank you very much for your presence.
Yes, sir. I understand, Your Honor. Actually, my secretaries, our secretary is in rush right now, so he sent me here to actually make the representation for the Department of Justice. But the questions have already been answered previously.
Yeah.
Yes, sir.
And probably next week on May 30, if you will be the one to receive to represent your secretary on the joint committee hearing of the good government and the Committee on Justice, rest assured that you will really be answering lots of questions on that Tadico investigation.
Yes, Your Honor.
Yes.
There is,
Mr. Chairman.
Yes, the Honorable Raul Delma.
Before you declare recess, you mean to say we're still going to invite them the last time? You know, they don't stay here in Metro Manila. It takes a lot of effort and a lot of expenses for them to come here. So those who have been adequately addressed, maybe we can dispense with their presence already.
You are right, the Honorable Raul Delmar. That is why we will be notifying after the evaluation on the result of this hearing. We will be notifying those officials that will still be invited in the next hearing, because we understand that these officials have also a lot of things to do in their respective area of concern. So,
I now move, Mr. Chairman, to suspend the committee hearing on this matter for lack of material time.
there's a motion to suspend the committee hearing, and
Seconded by the Honorable Delmar.
we will just...
I'm not seconding, Mr. Chairman.
But we are forced to go to declare a recess, and probably the next hearing will be during the next regular session, and that will be sometimes on August or September this year. So again, thank you very much. The hearing is suspended. Thank you, thank you. Ito. Oo. Di talaga. Kasi may...